May I have your lordship's leave to mention an original side matter, my lord? My lord, my client's account has been declared as a fraud account, my lord, without giving the forensic audit report. Settled proposition of law that without giving the documents declared as fraud, my lord. Apart from that, my lord, we have paid the entire dues of the bank. Bank has issued a no dues certificate as well, my lord. It's an original side matter. Any day in the next, my lord.
You file it?
We have filed it, my lord.
When was it filed? It will appear in usual course. There is no requirement of mentioning. All court applications appear on regular basis.
My lord, this was last listed in 2024, my lord.
So it's an old matter.
Since then, my lord, the entire dues of the bank has been paid. A no dues certificate has been issued, my
No,
lord.
no, I understand, but it's an old matter.
My lord, 2024 matter, my lord, last year, my lord, we have filed it.
Was it not taken up for consideration ever?
It was taken up for consideration. Talks for settlement was going on, hence the matter was adjourned, my lord.
Yes.
So today, my lord, the entire dues have been repaid of the bank, my lord.
Right.
If it
Give
can-
the slip.
I'm mentioning upon notice, I'll inform the others.
Yes.
Lordship, may I have a kind leave to mention for upgradation, Your Lordship?
Sorry.
My lord, may I be permitted to mention on matters item number 109 of today's list, the GST amnesty scheme paid from writ can be disposed
109?
of today's list.
109 of today's list. Nirmal Babu, likhun to. Today's list 109.
My lord, may I be permitted to
It has
mention?
become infructuous.
And my lord, one more thing, my lord,
The grievance has been redressed.
GST for 2016-17 and 17-18 has been they have paid, but they have not sent any notice for the period of 2019 and 20.
Whatever, if it's not there, not there.
May I permit to mention, my lord, I'm mentioning for extension of interim order, which will be expired on 8th April, my lord.
8th of April. Tuesday. All right. Give. Serve notice.
My lord.
Lordship, may I be permitted to mention this matter, Your Lordship? By an order dated 11th Feb, there were directions passed to exchange affidavits, and liberty was given to mention upon completion of the affidavits have been exchanged, Your Lordship. I'm mentioning upon notice. The petitioner is here. Kindly fixes a date for hearing, Your Lordship.
Petitioner is here. Who is
Yes,
the
Your
petitioner?
Lordship.
What is the matter about?
Well, there is a RBI circular which says that below 20 lakhs, my lord, remember, below 20 lakhs, SURFACE Act is not applicable. My lord remembers there is a circular where the
Yes.
below 20 lakhs, SURFACE Act is that. I have challenged that.
All right.
I have challenged that, my lord.
But then there are hearing benches. Why don't you go over there?
I was also suggesting
Please,
that
please, because this bench is
probably
so
my lord will not be able to take up and reach that position, even if it is
so
listed.
heavy with motions that hearing cannot be taken up. Yes.
I need to mention item number 93 of today's list.
Yes.
Well, this was the batch of 6 matters that I had moved. Mr. Banerjee was appearing. One pertained to the report, statutory auditor's report. Somebody came and said they were not represented. Lordship, direction was we serve and come back. So the matter is appearing as 93. There's some urgency. Lordship had heard it also a little bit. And they're going to take coercive steps. They're going to upload and make an FIR on the basis of those statutory audit reports. It was the 4 statutory audit reports which were...
Monday, I'll take up mentionings. Please mention.
I shall do that.
My lord, may I permit this mention this matter, my lord? Actually,
For what? For what?
This is in previous days, 3rd January 2025. This matter was there is some mistake in the classification in the cost title. So after perusal of the cost title, the previous bench was released this matter as classified as residuary classification. So for want of determination, it was released. Now this is under your determination, my lord.
Monday mention for inclusion. Call the list, please.
My lord, may I be permitted one matter to mention? My lord.
Lordship. Are you mentioning something?
My lord.
Yes.
My lord, this is a license suspension matter, my lord. Last time it was dismissed for default. And we have filed the restoration, my lord. It is running for a long time in the list, my lord. But it can't be reached, my lord. So it is my humble prayer to fix a date, my lord, for hearing of this
I'm sorry,
matter.
madam. Yes, item 1.
Lordship, I am appearing on behalf of the writ petitioner, Your Lordship.
Yes.
In this petition,
I am for the state in this matter, my lord.
Lordship, in this petition, Your Lordship, we have stated that the respondent number Lordship has taken the MSME certificate.
Anybody appearing for the state?
Your Lordship, I am appearing for the
My lord,
state.
I am appearing, my lord, for the state. She is assisting me, my lord. We are ready with the instruction. On yesterday, we have received the brief, my lord.
All right, yes.
Lordship, this matter, Your Lordship, the respondent number 2 has taken the MSME certification just to get the immunity of section 240 of the IBC Act, your lordship. What happens, your lordship? In IBC, the MSME, if the corporate debtor is MSME, in that case, the immunity of 240A, section 240A, your lordship, I will read it out at first. Your lordship. This is section 240A, your lordship. Kholo, tumi kholo. Before I start, your lordship, I want to just give you a little small backdrop. I will not take much time, your lordship. Section 240A, your lordship, says, notwithstanding anything to the contrary contained in this code, the provisions of the clauses C and H of section 29A shall not apply to the resolution applicant in respect of corporate insolvency resolution process. Your lordship, now my humble submission is kindly come to 29A. Section 29A.
Yes.
Lordship, persons not eligible to be resolution applicant. Your lordship, who all cannot become the resolution applicant. Your lordship, what has happened in this case, your lordship, the respondent number 3, if you will see, your lordship, they are the success. Your lordship, the company is the respondent number 2 company, your lordship, which is represented by now with the by the resolution professional. Your lordship, this is a company which has acquired the certificate of MSME just to give leverage to the respondent number 3 to become the successful resolution applicant, your lordship. Respondent number 2 was a company, your lordship, which is not a going concern since 2019, your lordship. And I will show you, your lordship, that in spite of having the status of not going concern, your lordship, they have acquired the certificate of MSME by playing fraud upon the MSME authority, as well as, your lordship, they have given data which are on the face of it very, I can say that it's playing, they have just given wrong data, your lordship, to acquire the status of MSME, your lordship. Now I will show you, lordship.
Where is the certificate? Is the certificate annexed?
Lordship, the certificate is annexed at page 295. 295, lordship. This company, your lordship, the respondent number 2 admitted into the CIRP on 22nd August 2023. 245, 249, 258, 258, 254.
Yes.
Lordship, kindly see, their MSME certificate was, kindly see page 258.
250.
Last line, 258, your lordship.
258. 258.
At first, 258, your lordship.
Tuhin Babu. 258.
See, your lordship, their registration certificate was valid till 30 June 2022 only.
Where do I get this date?
Your lordship, 258, your lordship.
Yes, valid till 30th of June 2022.
Right, lordship. Now come to 295.
Yes.
Page 295, your lordship. Page 295, your lordship, kindly see. They have again applied on 25th of August 2023. Dates are very important, your lordship. Why I am saying so? 25th of August 2023. Your lordship, if you will see the order of the CIRP, your lordship, the date of the order of the CIRP. Page assist me.
27,
Page 27. I will, page 27, your lordship, kindly see. The company was admitted into the CIRP 22nd August 2023. On page 27 of the volume 1. Lordship, the company was not a going concern, neither the information memorandum nor any document which was provided was having any information regarding that the company is a going concern, your lordship. Now, your lordship, kindly see again to page 275. Kindly come. Your lordship, kindly see 25th of August 2023 they have applied. Date of, your lordship, kindly see the major activity, Your Lordship. Kindly see 20. Lordship, I will take leave. I am led by Mr. Jishnu Shah. Your Lordship.
Leave now.
Leave me. I have taken leave.
Lord, I'm very sorry, my lord.
No, it's all right.
My lord, the very short matter, my lord, may I just start with the law? My lord, Lordship knows that nowadays, my lord, companies are admitted into insolvency under the Insolvency and Bankruptcy Code. Now, my lord, naturally, the object is to resolve the insolvency. For resolving the insolvency, my lord, resolution applicants come forward to give their bids. Now, my lord, there's a disqualification there under the statute. It says if you're a related party, you cannot give a bid. That's section 29A. And my lord, secondly, my lord, there's an exception carved out there also. It says the related party bar will not apply if today you're a MSME enterprise. That is the corporate, that is the MSME enterprise. So, my lord, the declaration of MSME status becomes very relevant. Because, my lord, here an exception is being carved out to admit or allow, my lord, a promoter, my lord, or a related party of a promoter who is responsible for sending the company to insolvency to, my lord, take it over, notwithstanding the bar. So, my lord, that is why it becomes very important. Now, my lord, in this case, my lord, what had happened is the company, my lord, went into insolvency. My lord, there is a default, my lord, in excess of 3,500 crores. Well, that is the extent of default of the company. Well, this is default of public money. Now, well, the company was admitted in insolvency on 22nd August 2023. Well, now, very important is its manufacturing activities had been stopped before that. Well, two dates I'll show you, Lordship. Well, please have a look at two certificates. Well, at page 259.
Yes.
Now, well, this your Lordship will find at page 259. Well, it is a letter from the WBSEDCL. Well, please see item number 1. This is, my lord, reference your memo dated such and such, consumer ID such and such, service location, Moza Bhiringi, Durgapur. And, my lord, here, my lord, this is about outstanding dues of Jagodamma Industries Limited. That is the respond number 2 corporate debtor. And please see physical disconnection was executed on 8th August 2023. So the electricity is disconnected even before the CIRP commences. And then the next document your Lordship will kindly see, next page itself, 260. My lord, here your Lordship will find that, my lord, again, a memo from the WBSEDCL, my lord, which is again with regard to now, the service location is, again, my lord, Gopinathpur, Sharbanga, Durgapur. Physical disconnection is effected on 22nd May 2019. So, my lord, the company was not functioning at all. Now, my lord, the criteria for declaration of MSME status is twofold. Investment in plant and machinery and turnover. My lord, a company which both its units are shut because electricity has been disconnected could not have any turnover. My lord, I have also obtained photographs to show your Lordship that, my lord, plant and machinery have all been sold. It's a jungle. Now, my lord, so far as this is concerned, my lord, we raised 2 objections with regard to, my lord, the respond number 3, which was declared by, my lord, the Committee of Creditors with the resolution professional of the respond number 2 as, my lord, the successful resolution applicant.
How are you related with this private respondent?
I am, my lord, an applicant. I am a resolution applicant.
Right.
My lord, my application has been, my lord, not considered, saying that respond number 3 is, my lord, my lord, qualified applicant who is not subject to the bar of related party or, my lord, MSME. Now, my lord, when we raise this objection saying that no, you're a related party, so you're barred, the resolution profession writes back to us saying that no, you're not a related party, which is a matter, my lord, which ultimately will be considered by the NCLT. But notwithstanding any of that, because of the MSME status of the unit, today the bar of related party will not in any event apply. Now, my lord, so far as this is concerned, my lord, my lord, relies on a certificate. If your Lordship will kindly have a look at, my lord, page, my lord, 253. Well, 253, your Lordship will kindly have a look at. This is what he discloses. Well, he discloses this to be, my lord, an application or, my lord, a certification by the MSME authorities. At 253, your Lordship will find serial number 7, name of enterprise, Jagodamma Industries Limited. Now, my lord, 11, serial number 11. 7 is, my lord, name of enterprise. 11 is date of commencement is, my lord, kindly see 25th May 1993. Now, my lord, if your lordship sees, my lord, this does not mention, my lord, up to when the certificate is valid, when it came to an end, nothing. Now, my lord, when we raised an objection with this regard, my lord, please now have a look at the next certificate which we had disclosed, which is page 258. Now, my lord, this certificate shows, again, your lordship will find date of commencement is 25th May 1993. And my lord, at the bottom of the page, your lordship will find the Udyog Aadhaar Memorandum certificate is valid till, kindly note the date, 30th June 2022. So, my lord, on 30th June 2022, this certification came to an end. Now, my lord, this certification is, my lord, required to be renewed. And my lord, the renewal is takes place on the basis of reclassification as well as the government decides from time to time. What will now be the criteria for deciding as to whether it is an MSME unit or not? Now, my lord, when we, my lord, point this out, my lord, then immediately, my lord, he comes forward and, my lord, in a supplementary affidavit, he discloses another certificate. Please have a look at this at page 295.
Yes.
Now, my lord, please see this certificate at 295. This is what he discloses now, says, no, this is the MSME registration. Now, my lord, please, my lord, kindly see two things. My lord, the classification date on the top right-hand corner. My lord, kindly see 2324. The classification date is 25th August 2023. Now, my lord, your lordship remembers that 22nd August, my lord, the CIRP commenced. 2019 electricity disconnected. August 2020, the second unit electricity disconnected. CRP starts on the 22nd of August. And my lord, here on the 25th of August, my lord, he's supposed to have obtained another, my lord, registration. My lord, naturally, the question is, my lord, how could you have obtained this registration? Because the unit is stopped, there's no turnover, no plant and machinery, and my lord, there is no, my lord,
Electricity.
That's right. Now, my lord, either, my lord, it is on the basis of, my lord, some kind of understanding, or it is simply, my lord, a mindless exercise by the authority, my lord, in granting the exercise, saying, I made a declaration, I'm an unit, so please give me registration.
So you challenging this?
Yes, my lord, I have
declaration of MSME.
I have, my lord, raised this question. My lord, now, my lord, once the COC approves the plan submitted by the respondent number 3, it has to go to the adjudicating authority or the NCLT for approval. At that stage, my lord, I come forward and make an intervention application saying that, no, you can't approve this because this is barred by law. He is not a qualified entity at all. My lord, that application is pending. Now, my lord, the NCLT, with the greatest respect, does not have the jurisdiction or, my lord, the authority to decide as to, my lord, whether this MSME certificate is validly granted, not validly granted, my lord, upon practicing fraud or whatever. My lord, since it does not have the jurisdiction, and since, my lord, I failed to, my lord, ultimately persuade the resolution professional to, my lord, look into the brighter side of things, because, my lord, obviously it is a document, my lord, which is procured. My lord, then I've come to your lordship. Now, my lord, the first objection that is raised before your lordship is that this is not maintainable. Now, my lord, why is it not maintainable? My lord, there can be two reasons. I'm, my lord, now presuming this. One is, my lord, my locus. Now, my lord, the law is very well settled now that because I'm interested, I have a stake in the, my lord, scheme of things. I've put in my expression of interest. I'm, my lord, an intending resolution professional. My lord, so I have a locus. My lord, I have the judgments. I'll not trouble your lordship immediately. If my learned friends take the point, I shall show your lordship. Second, my lord, there is the question of, my lord, whether it is the NCLT and NCLT alone that can decide this question. My lord, now under section 231 of the code, my lord, it says everything that the NCLT can decide will be decided by the NCLT, not by a civil court. Of course, my lord, the writ court's powers are, my lord, much more expansive. My lord, it will not fall within that category. But, my lord, nonetheless, my lord, that is, my lord, the law. Now, my lord, so far as this is concerned, my lord, in similar matters, my lord, the NCLT, which is the appellate authority of the NCLT, has held that, my lord, these are questions which cannot be considered by the NCLT. MSME registration is not a matter which can be considered by the NCLT. My lord, may I just hand up to your lordship, my lord, one judgment. My lord, this is an NCLT judgment, my lord, on the same issue. Yeah. My lord, this is, my lord, passed by Justice Ashok Bhushan, my lord, who is now the chairperson of the NCLT. No, no. Well, let's kindly just have a look at paragraph 24. Paragraph 24, my lord, is the relevant paragraph. I don't need to trouble your lordship with anything more than that. It says the MSME Act as it stands clearly does not provide any supervisory role on the adjudicating authority to revise, modify, revoke or interfere with the MSME registration at its level. Clearly, the notification framed thereunder also does not bestow upon the adjudicating authority with any such authority to hold an MSME registration certificate to be null and void on its own. Even if the adjudicating authority was so much convinced or persuaded to believe that there were errors in the calculation of written down value in the grant of MSME status, to our minds, before embarking on any exercise of unilaterally undertaking calculation of the WDV at its own level, the adjudicating authority ought to have asked itself the question as to whether the Parliament, while framing the MSME Act, intended to bestow such an authority on it. In the exercise of summary jurisdiction by the adjudicating authority under IBC, the adjudicating authority is not expected to go into the details of accounts and examination of certificates issued by the competent authority under MSME Act and notification issued thereunder. MSME registration can only be revoked by a competent authority, and the adjudicating authority cannot arrogate this jurisdiction upon itself to modify, revise, revoke, or interfere in any manner with the MSME registration granted by the competent authority. We are of the considered opinion that the MSME status of the corporate debtor as granted by the competent authority continues to subsist and could not have been disregarded by the adjudicating authority. Now, this is the NCLAT view. Now, this matter went to the Supreme Court. This was challenged before the Supreme Court. May I hand up to your lordship the Supreme Court judgment? Well, this is a very recent 2025 judgment. Well, a short judgment. Well, may I just show your lordship? Well, 3 paragraphs. Paragraphs 3, 4, and 5. The application for registration as an MSME was filed by an employee of the corporate debtor. So, one of his employees simply goes and files an application saying declare. Messrs. Etco Denim Private Limited, and on the same day, certificate dated 23rd October 2020 was issued. It is the contention of the appellant, Central Bank of India, that the certification has been wrongly procured and is contrary to law. We are conscious of the fact that we are hearing an appeal in terms of Section 62 of the IBC, and within its limited confines, we cannot go into the question of the validity of the registration certificate dated 23rd October 2020. At the same time, the certificate having been placed on record, Section 29A read with Section 240A of the IBC would come into play and would affect the interests of the secured creditors, including the appellant Central Bank of India. Keeping in view the peculiar facts of the present case, we would permit the appellant, Central Bank of India, to file a writ petition before the jurisdictional High Court challenging the issuance of the MSME registration certificate dated such and such. If any such writ petition is filed, we request the High Court to take up the same for hearing expeditiously and preferably decide the same within a period of 6 months, etc. Then, my lord, 7 is paragraph 8 is very important. In the meanwhile, the proceedings before the adjudicating authority and the corporate insolvency resolution process shall remain stayed. The reason is, my lord, because it is, my lord, a process which ultimately has to be sanctified by the actions of all the parties in a bona fide manner. Now, my lord, today, if a person, my lord, despite being ineligible, my lord, on the basis of a procured registration certificate from the MSME authority comes forward and says, no, I am eligible, notwithstanding the fact I am a related party and subject to the bar under 29A, my lord, that itself is an act of fraud on court. And my lord, the court before which the fraud is to be perpetrated will have no jurisdiction to decide this question, because it has no jurisdiction to decide whether it's validly issued, not validly issued, my lord, all these questions. Now, my lord, we made repeated complaints in this regard with that regard before the authority is concerned. They are all on record.
Where is it?
My lord, yes. Well, if your lordship will kindly have a look at, my lord, the complaints. My lord, from 345 onwards, my lord.
But 345 is the response number 1.
Well, at 333 onwards, where the complaints are made, and to the response number 1, it is at 345. From 333 onwards, regular complaints, and 345 is the complaint made.
February 2025.
That's right. Now, my lord, once we move the writ petition before your lordship, my lord, immediately my learned friends, my lord, go to the NCLT and say, it is a time-bound process, it is being delayed, you're trying to delay the whole process, and my lord, they get the matter fixed today. It is item number 101, which is at the top of the board today. Now, my lord, all that I'm very humbly praying is, my lord, on the face of it, my lord, the certificate could not have been obtained. If the certificate could not have been obtained, this is an attempt to, my lord, practice fraud on the tribunal, against which fraud, in view of the judgments of the NCLT and, my lord, the Supreme Court, it has no, my lord, jurisdiction or, my lord, authority to protect itself. it must accept the certificate as it is. My lord, in these circumstances, my lord, if today the matter is decided on the basis of the certificate that is produced, then, my lord, I shall be left nowhere. My rights will be frustrated. My lord, only one more thing. My lord, if your lordship will kindly see the balance sheet of, my lord, the respond number 2 company, my lord, that is, your lordship will find, is at page 405. My lord, I want to show your lordship why, my lord, this is so stark on the face of it. At page 305, my lord, this is the balance sheet for the year ended 31st March 2023. And, my lord, the CIRP commenced on 22nd August 2023. My lord, please see, my lord, here, these are, my lord, the earnings, revenue from operations at 405, the first item. Now, kindly see, my lord, on the top of, my lord, the columns, rupees in thousands. So, my lord, it's in 1,000 rupees. Revenue from operation in 2022 was 23,197 rupees. And, my lord, in 2023, 31st March is 48,382. This is the total revenue from operations. Thereafter, my lord, if your lordship sees, my lord, the notes, my lord, of the balance sheet at page 351. Well, this is the third volume.
Yes.
Item number Roman 17.
Yes.
The creditor lender of the company has initiated proceedings against the company before the NCLT for recovery of the dues, considering that and considering the company's poor financial positions, we do not foresee the company can continue as a going concern. So, my lord, it is not, my lord, a going concern at all.
What is this 351?
This is, my lord, a part of the balance sheet.
The company's balance sheet.
The company, number.
Independent auditor's report.
It starts at 349.
Yes.
My lord, and, my lord, thereafter, if your lordship sees, my lord, at page 353, the second paragraph.
Yes.
In preparing the financial statements, management is responsible for assessing the company's ability to continue as a going concern, disclosing as applicable matters related to going concern and using the going concern basis of accounting, unless the management either intends to liquidate the company or to cease operations. And, well, then it goes on to say at 357, well, the balance sheet has not even proceeded to verify the plant page. Please see 1B, 357. The property, plant, and equipment have not been physically verified by the management during the year, hence could not be commented upon. Now, my lord, this is, my lord, the reason I'm showing to your lordship is, my lord, this. My lord, this is the state of the plant and machinery. I shall give my learned friends a copy. My lord, these are absolutely recent, my lord, photographs taken. Well, there is nothing but jungle there. Well, if your lordship, my lord, were to direct any one officer to take an inspection, lordship will find no plant, no machinery, no business, no enterprise, no electricity, nothing.
How are they interested if there is nothing?
Well, I am interested because, my lord, I am ultimately interested in resolving the insolvency within the, my lord, parameters of the court. The question is, my lord, is my learned friend entitled on the basis of a MSME registration? Whether he's a related party or not, I shall argue that before the NCLT. And, my lord, RP is, my lord, applying for renewal of the registration certificate, MSC registration, for the promoters on the basis of, my lord, these kind of, my lord, averments. Well, obviously, on a misrepresentation, and, my lord, now I understand that, my lord, pursuant to these complaints and after the petition has been filed before lordships, the authorities are, my lord, planning to make an inspection either today or tomorrow. Well, that is, my lord, my instruction.
My lord, it has been done, my lord, from our end, my lord.
Oh, it has been done.
My lord, my instruction is there, my lord. My lord, they made their complaint on 12th of March 2025, my lord. Then, my lord, on 13th, that is before the GM DIC Durgapur, my lord. My lord, page 9 of my instruction, my lord.
Yes.
Now, my lord, thereafter, my lord.
Please wait, Mr.
My lord.
Farmania.
My
The
lord.
inspection report says the unit has been identified by the local people. There was no
My lord.
signage on the unit premises. The locals reported that the unit has been closed for some years. All the machineries have been dismantled and no employee worker are available in the unit premises.
I'm grateful, my lord. That answers
This
the question.
is the report of the general manager, director of District Industries Center.
Well, this answers, my lord, the question.
My lord, one more part is there, my lord, for submission, my lord.
How is it that the MSME registration certificate is still there if the company does not exist?
My lord, this renewal is being done on the basis of self-declaration, my lord. And after receiving
Then
the
you take
complaint,
steps
my
for
lord, we are
cancellation.
not the parental body, my lord.
Why don't you take
Lord,
further steps in response
my
to
lord,
the
my lord, we are not the parental
inspection?
body. My lord, the Ministry of MSME, Government of India, is the parental body. Ultimately, the license will be cancelled by the Ministry of MSME, my lord. My
But
lord, for
this
proper
report,
adjudication of the matter, the Director MSME DFO and Ministry of MSME should be added as a party, my lord. My lord, kindly see the letter which has been given to your ladyship, my lord. My lord, the inspection report, my lord. At the bottom, your ladyship will find, my lord, the letter has been forwarded to the Director MSME DFO, Durgapur, my lord. That works under central government, my lord. My lord, my lord, the instruction, my lord, the bunch of papers, my lord, which is there, my lord. On the very first page, your ladyship will find the flow chart, the action which should be taken, my lord. Your ladyship will find at the bottom, my lord, the complaint will be there. Then the general GM DIC undertake inquiry that has been done from our end, and my lord, thereafter, my lord, the forward the matter to the Director MSME or Director MSME DFO, that is the central agency, my lord, concerned, my lord. Then
it's
the
mentioned state
notice will be issued,
number 3 in the
my lord.
flow chart is MSME DFO concerned of the state government.
Then,
See,
my lord, kindly come to the last point, my lord, the last right inside,
that
my
is
lord.
the extreme one.
My lord, the based
Booking
upon the
of
finding the
registration.
direct, my lord.
Very well, I have followed the stand of the state also. You are
My lord.
representing, are you representing?
I represent the resolution professional.
Yes.
The company law, which is in the process. Lord, may I have 2 minutes of your lordship?
Yes, yes. Respondent number 2, Jagadamba, are you
Jagadamba.
represent?
Yes. Lord, kindly, Lord, see the order dated, Lord, 22nd August 2023, by which, Lord, the company was, Lord, admitted into the corporate insolvency resolution plan.
Which page do I get that?
Please come to, Lord, the order starts, the operative part is at page 58. The order, Lord, starts just before that, Lord, it starts from page 46. Sorry, it starts, Lord, even earlier. It starts at,
You are referring to page number?
Lord, I am referring to page, Lord, 56.
All right.
That's the operative part of the order.
Yes.
Lord, paragraph 47. Lord, the banks, Lord, who are the creditors, this was, Lord, a petition presented by the banks. And, Lord, at their instance, this order was passed. Paragraph 47 and 48, if your lordships kindly take note of. 47 is, therefore, we find that the present petition filed by the financial creditor is complete in all respect, within limitation, and deserve to be admitted. Then 48. In the light of the above position of facts, record, and law, it is hereby ordered as follows. The application so-and-so, Asset Reconstruction Company Limited, etc., for initiating CRP against Jagadamba Industries Corporator is hereby admitted. There shall be a moratorium under section 14 of IBC. The moratorium shall have effect from the date of this order till the completion of CIRP or until adjudication authority approves the resolution plan under subsection 1 of section 31 of IBC or passes an order for liquidation of corporator under section 33 of IBC as the case may be. Then, Lord, is
the writ court required to go into all these things?
Because, Lord, the
Why?
moratorium section has to be looked into. Your lordships may kindly have a look at section 14. Kindly, Lord, have a look at section 14.
But why will it be looked
Because,
into?
Lord, these certificates are all protected under the moratorium. Your lordships may kindly...
Let it remain protected. The court is not passing any order as such. But since the director of industries has caused a spot inspection and found that the company is not there and it is forwarded its report to the superior authority.
Once it goes into the resolution process, it is just like a liquidation. But, Lord, the here under the IBC, the stage is that one tries to revive the company. The process of revival is on. That will be up to section 31. If the process of revival fails, then Lord, it goes under 33 for liquidation. We are under the process of revival. Now, Lord, in the process of revival, Lord, there are two plans which were submitted. One by the successful resolution applicant, who is respondent number 3. One by the petitioner, who had filed their plan. The plan of the petitioner has been rejected by the committee of creditors, who are the representative of the financial creditors. They have rejected the plan of the petitioner. On his rejection of plan, he files this writ petition. Now, the issue is that, whether this benefit will be passed on to the buyer who will ultimately take over the company, the successful resolution applicant.
Respondent number 3.
Or, the plan will not be approved. That will be an issue which will be gone into, because the same issue the petitioner has raised before the NCLT. Your Lordships may kindly see.
Well, let that be decided by the NCLT.
Because, the plan is coming up. Plan is coming up for approval under section 31, subsection 1 to 4. Now, this is the stage where he has approached. Today he has no status because his resolution plan has been rejected. So, question today is whether, he can apply for cancellation of the registration. That's why I said,
irrespective of the fact whether he applies or not, since a complaint has been lodged and a spot inspection conducted, let the consequent steps be taken. Thereafter, you proceed with your
kindly
matter.
have a look at section 14 once. After that, whatever your Lordship directs, please have a look at section 14 of the IBC.
Yes.
It says, subject to the provisions of subsection 2 and 3, I am reading 14(1). On the insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following. Namely, A, the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of judgment decree, etc. Now, this initiation of proceedings itself is what? Then, please come to the explanation part. For the purpose of this subsection, it is hereby clarified that notwithstanding anything contained in any other law, for the time being in force, a license, permit, registration, quota, concession, clearance, or a similar right given by the central government, state government, etc., or any other statutory constituted under any other law for the time being in force shall not be suspended or terminated on the grounds of insolvency. So,
you are saved by this clause.
This is complete protection granted during the moratorium period.
Yes.
And my learned friend is complaining that, the status was tried to be continued by the resolution profession. And that is exactly what is done. Because of the moratorium, the same status continues. It does not change. My learned friend has cited, Supreme Court judgments and all. I'll come to that. Those were all, in a situation where, the secured creditors were being treated fraudulently. That is the reason, this protection. Here, they have not made the banks a party.
And the insolvency commencement date over here is?
Yes, by this order, 22nd August 2023. Your Lordships may kindly have a...
22nd August 23.
Yes. And the point today is the resolution professional had applied for the renewal. The resolution professional had renewed it, not any third party. And this company is being projected, they had also applied as an industry, having certain benefits. This will inure to the benefit of the secured creditors who are going to get a little more higher price. This is the whole object, and they have not made the banks a party. The financial creditors are not party to this writ petition.
Because the issue is different. Only the MSME.
Issue is also touching their right. Issue is also touching their right. I as a resolution professional, I did not act, contrary to the interest of the secured creditors. Therefore, their interest will also have to be looked into. And today, kindly consider his status. He is a resolution applicant whose application has been rejected. Now, what status he has, local standard he has, to maintain this writ petition.
May I answer in 2 sentences?
The 30 and 31. This is a complete procedure. And he has taken this point that they are related parties. Therefore, the first person whose bid has been accepted, he should not be, his resolution plan should not be accepted. That's a matter, Lord, for consideration of the NCLT. NCLT may not accept, Lord, that offer, may say that you go in for a fresh advertisement or whatever, or may do whatever, Lord, the NCLT directs. But, Lord, today, Lord, it will be a situation where, Lord, unnecessarily this writ petition will create a complication. What they want, that once this termination or this registration is cancelled, then, Lord, they would go and say that.
Why are you taking it that the registration will be cancelled?
No, I am
It
not.
may not be.
I am not saying the registration can't be cancelled because of Section 14. Now, Lord, I am just saying if they are clothed with a writ court order directing authorities to look into it at this stage, Lord, this might have some cascading effect. As a resolution professional, my job is to see the company secures the best price at this stage of revival. This is a stage of revival. My learned friend is showing photographs that there are jungles, etc. If they are not interested, let them walk out. Nobody is compelling them to come and give offer. But, Lord, if they are participating and they want the first offerers to go, and that is the reason why this writ petition has been filed. Now, Lord, my humble submission is kindly do not entertain this writ petition.
Very well.
Yes, my Lord, I am for response number 3. My Lord, first, my Lord, kindly look at the judgment which they have relied upon, my Lord, the Supreme Court judgment. It's, my Lord, in a completely, my Lord, different context, and I just want to show that, my Lord. Kindly look at it, my Lord. My Lord, kindly come to first page 2. My Lord, we'll find, my Lord, it starts with during the pendency. During the pendency of the aforesaid proceedings, my Lord, has that?
Yes.
It is apparent that the resolution professional instructed employer of the corporator to make an application for registration of the corporator as a micro, small, or medium enterprises under the Micro, Small, and Medium Enterprises Development Act 2006 in terms of gazette notification. It is the case of the appellant, my Lord, very important. Central Bank of India, my Lord, is a financial creditor. Central Bank of India, that it objected to the corporate debtor. Messrs. Etco Denim Private Limited being treated as an MSE, and these objections were noted in the meetings of the Committee of Creditors. It is also the case of the appellant Central Bank that the asset value of the corporator ITO was more than the norms prescribed to qualify. The application for registration as MSME was filed by the employee of the corporator, Sunsach, and the same day certificate was issued. It is the contention of the appellant Central Bank of India that the certification has been wrongfully procured and is contrary to law. Then we are conscious of the facts. Then kindly see what was being heard. We are conscious of the fact that we are hearing an appeal in terms of Section 62 of IBC, and with the limited conveyance, we cannot go into the question of the validity of the registration certificate dated 23rd October. At the same time, the certificate has been placed on Sun. Then, kindly the next paragraph. Keeping in view the peculiar facts of the present case, we would permit the appellant Central Bank. So, my Lord, first thing to be noted, my Lord, is that, my Lord, they are not Central Bank of India. They are not financial creditors, my Lord, in the proceeding. They are, my Lord, Tech Nirman, who's, my Lord, an unsuccessful resolution applicant, and that is significant, my Lord. That, my Lord, is significant. Second of all, my Lord, Central Bank of India, who are stakeholders and involved in the insolvency proceedings, had opposed in the Committee of Creditors, which, my Lord, knows is the governing body, my Lord, which drives, my Lord, an insolvency. Thirdly, my Lord, also the fact that, my Lord, Central Bank, having, my Lord, a stake, my Lord, could have objected, not, my Lord, Tech Nirman. Now, my Lord, the law, my Lord, there are two judgments, my Lord, my learned junior will hand over. Both, my Lord, knows that, my Lord, Ursula Mittal and, my Lord, another judgment of the NCLAD also, which says, my Lord, that as an unsuccessful resolution applicant, he cannot come and oppose in, my Lord, the resolution process itself. Because what has happened today? My Lord, today, my Lord, the corporate debtor, my Lord, I am, my Lord, the successful resolution applicant. The Committee of Creditors today, who are, my Lord, the financial creditors, have approved of me as well as a successful resolution applicant. That application is pending, my Lord, before the adjudicating authority. They have also made an application for intervention trying to, my Lord, oppose the, my Lord, affirmation or, my Lord, approval of the resolution plan. Quite naturally, my Lord, both the resolution professional and I have taken a point that he has no locus standi. Now, to file a writ petition, and as soon as, my Lord, entertains this writ petition, he will go before the NCLT and say that, look, now I have a locus because the High Court has recognized my locus. Now, this is, my Lord, what we want to, my Lord, avoid at any cost. Because by this,
where is the judgment?
My Lord, by this, my Lord, kindly look at, my Lord, Ursula Mittal.
Yes.
And look at paragraph 80. It's 2019 2 SCC, page 1. And kindly look at paragraph 92 straight away. 82 straight away. At page 87.
Yes.
Kindly see the last 3 lines of that page. It is clear. At this stage, again, no application before the adjudicating authority could be entertained, as there is no vested right or fundamental right in the resolution applicant to have its resolution plan approved, and as no adjudication has yet taken place. Then 83, it is the committee of creditors which will approve or disapprove a resolution plan given the statutory parameters of section 30 under regulation 39 of the CRP regulations 3 such. Then kindly look at another of persuasive of some value of the NCLAT. Kindly look at so here it says no vested right to have a resolution plan approved. So my learned friend having lost has even far less right than trying to say that you please approve a resolution plan in my favor. Then kindly look at another judgment from the appellate tribunal, which is really the specialized tribunal to look into these things. M.K. Rajagopalan. Please give that.
Yes.
M.K. Rajagopalan, this is at paragraph 31. At page 21 of 22. Has that bullet?
Yes, yes.
On a careful consideration of the respective contentions advanced on either side, this tribunal, keeping in mind of a vital fact that the petitioner appellant being an unsuccessful resolution applicant, which admittedly the writ petitioner is, has no locus standi to assail a resolution plan or its implementation, coupled with the candid fact that he is not a stakeholder as per section 31(1) of the IBC in relation to the corporator. This tribunal, without any haziness, holds that the petitioner appellant is not an aggrieved person coming within the ambit of section 61(1) of the IBC, especially when he is not a privy to the resolution plan viewed in that perspective leave sought for an I number source merit. So this is exactly what he wants to do. He's filed an intervention application. He has no right. If the financial creditors or a stakeholder had come challenging this, then it would have been a different issue. But he is a complete third-party outsider whose plan has been rejected by the COC, who are the committee of creditors. Now, through this backdoor, he wants an entry into the resolution process itself. Kindly do not permit that. Even if looks at a locus standi for a writ petition, will also find we have that 1976 1 Supreme Court cases 671. Look at where he must have a vested right to really also file a writ petition. Kindly just look at this judgment also. Aware of it, I don't need to, but just for the sake of this is paragraph 48. Will find. At page 686. This is in case of a writ petition. In the light of the above discussion, it is demonstrably clear that the appellant has been denied or deprived of a legal right. He has not sustained injury to any legal protected interest. In fact, the impugned order does not oppose the decision against him, much that does it wrongfully affect his title to something. He has not been subjected to a legal wrong. He has suffered no legal grievance. He has no legal peg for a justifiable claim to hang on. Therefore, is not a person aggrieved and has no locus standi to challenge the process of the no objection certificate. Here there was a case of no objection certificate. If this has to be challenged, it can only be by one of the stakeholders. Because what happens, knows when a company goes into insolvency, the status of the company has to be preserved. So, if it is an MSME, it has to be continued as an MSME for the purpose of ensuring that the best realizable value is had for the company itself, for the insolvent company itself. Now, here, the fact that he shows there's jungle and all that is irrelevant, because the criteria required is it has to be less than 50 crores turnover, and plant and machinery has to be less than 50 crores. That is the criteria which is required. And from the balance sheet itself, it will appear that only plant and machinery, and there are definitions to that effect with regard to plant and machinery. It is less than 50 crores.
Very well.
Now, one more, just tiny look at this authority. This is the Farooq Ali judgment, which in fact the Honorable Supreme Court also said that process of insolvency should not really be interdicted by the writ court. Can you just look at that, because this is exactly what he wants to do. Kindly give that Muhammad Enterprises judgment first, Rajesh. Mr. Banerjee, kindly give that.
Yes.
In this Muhammad Enterprises versus Farooq Ali Khan, and kindly look at paragraphs 11 to 14 of that judgment. Rather, paragraph 12. Further, I'm sorry, I hope we have the same.
Yes, yes. Further.
Further, it is also an admitted fact that on 6th October 2022, Respondent 1 moved an interlocutory application before the adjudicating authority seeking rejection of the resolution plan filed by the appellant. Grounds taken in interlocutory application same those in the appeal. It is not as if the High Court was unaware of the Respondent 1 availing the statute remedy under the code. At least on this ground, the High Court should have relegated Respondent 1 to the procedure under the code and permitted him to continue the remedy that he has chosen to adopt. We may hasten to add that it is not necessary for us to enter into the merits of the matter to examine the amounts offered by the Respondent 1 and contrast with the offer made by the applicant. The jurisdiction and power of the adjudicating authority under Section 65C has already been reiterated by this court in Committee of Creditors of SR Steel versus Satish Kumar and Gujarat Urja. It is important to note that CIP proceedings commenced on 26/10/2018, 6 years ago, and the resolution plan of the appellant was approved in 2020, 4 years back. Importance of concluding the CIP proceedings was highlighted by this court on a number of occasions in a recent order in Committee of Creditors of KSK and such, Uttar Pradesh Power. This court has observed that an unjustified interference with the proceedings initiated in insolvency breaches the discipline law. In view of the delay in proceeding, High Court, particularly Respondent 1 has himself initiated proceedings under the code for filing interlocutory application. Similar relief, we are of the opinion High Court committed an error in entertaining the writ petition. Apart from delay and latches, this should also be noted. And my lord, at Arrogance answer, paragraph 15, my lord, really rounds it off by saying the supervisory review powers vested in the High Court represents critical constitutional impact. Here, the exercise demands rigorous scrutiny and judicial application is not a case to interfere. And my lord, there is another judgment of the same name, Farooq Ali versus Bank of Baroda. There also, my lord, will kindly, my lord, have a look at my lord, paragraphs 11 to 14. Kindly look at my lord, paragraph 11. It is well settled, my lord. It is well settled.
Yes.
Sorry, my lord. It is well settled that when statutory tribunals are constituted to adjudicate and determine certain questions of law and fact, High Courts do not substitute themselves decision-making authority while exercising judicial review. In the present case, the proceedings had not even reached the stage where the adjudicating authority was required to make such determination. Rather, the High Court exercised jurisdiction even prior to the submission of the resolution provisional report, thereby prejudicing the applicant's adjudicating authority from performing its adjudicative function under the IBC code. This was a section 95, where also the tribunal is the authority. While there is no exclusion of power of judicial review, paragraph 12, of High Courts, and the limits and restraints that the Constitutional Court must exercise are well articulated. The primary issues involved in the present case, including the factual determination whether debt exists, part of the statutory and regulatory name of the Insolvency and Bankruptcy Code. In fact, the entire rationale behind appointing a resolution professional. Then, my lord, kindly see paragraph 13. It follows the other Farooq Ali, which I, my lord, quoted and said, my lord, that the petition should not be entertained. In the writ petition, kindly turn to the writ petition once more and kindly look at paragraphs 4, 5, and 6. What is the case? Ultimately, they want as a second unsuccessful resolution applicant to throw me out of the process. Kindly look at paragraphs 4, 5, and 6. The Respondent number 3 is an unlisted public limited company. Respondent number 3 has been declared the successful resolution applicant of the Respondent number 2 by the Committee of Creditors of the Respondent number 3. Credit after referred to as the COC in or about. Kindly look at the date, September 21, 2024. That's when, my lord, my resolution plan has been approved by the Committee of Creditors. The resolution provision respondent has filed the resolution plan submitted by the respondent 3 for approval of the Honorable National Company Law Tribunal by filing an interlocutory application. The said plan has been challenged. Can you see? The said plan has been challenged by the petition number 1, which is one of the writ petitioner. Vide its application IA 209224, which is presently pending adjudication. In the case of the petition, respondent number 3, the related party of respondent 2 and consequently could not have submitted resolution plan on account of the bar under section 29A of the code. Plan submitted by the respondent 3 could not have been entertained by the resolution provision or have been taken for consideration or voted upon by the COC of the respondent number 2. There could not consequently be no question of the same being approved by the COC of the respondent 2. Such circumstances, your petitioners challenge the approval of the resolution plan of the respondent number 3 by filing an intervention application being IVN number 39 KB before the National Company Law Tribunal, while application presently pending consideration, copy of the petitioner's intervention application. So, my lord, he says he's filed 2 applications for the purpose of, my lord, challenging the resolution plan which has been approved in my favor. Now, what is he trying to do, my lord, with the greatest of respect in this writ petition? The ultimate result is, my lord, to go back and challenge my resolution plan. Now, with the greatest of respect, my lord, why should the writ court today, my lord, permit him to, my lord, overtake that process and, my lord, come before the writ court and say that, no, now please look into the fact of whether the MSME certificate should be renewed or not. He can't do that because that's exactly, my lord, this is, my lord, a way to try and, my lord, defeat the insolvency resolution process, my lord, which he can't do directly. Because there, my lord, the adjudicating authority may hold, sorry, you're an unsuccessful resolution applicant, you have no locus, and therefore we are not going to entertain your application. Because you must be a stakeholder in a corporate debtor. And my lord knows these terms, my lord is using, my lord, and my lord deciding on these matters. Because the COC committee of creditors are the ones, my lord, who decide on the resolution process. They are the ones, my lord, who have the biggest stake.
You must be over by now.
My lord, yes, my lord, my lord, that's my submission. My lord, saying, my lord, the writ petition, my lord, should not, my lord, be entered in at all, my lord, at this stage.
Submission. My lord, first, Mr. My lord Kaur, he takes the point of, my lord, continuing, my lord, MSME certification because section 14 applies. He says the moratorium applies. Now, my lord, your lordship has seen.
No, first of all, you say your locus standi.
Yes, my lord. Kindly just give me 2 minutes. I'll be very brief. My lord, first, my lord, certificate is still 30th June 2022. 14 months gap, renewed after 14 months. Your lordship has heard that my learned friends, my lord, from the MSME authorities have said it is not done on the basis of self-declaration. Kindly ask Mr. Court to show what is the self-declaration he made with regard to plant machinery, with regard to, my lord, turnover, with regard to business. Number 1. Number 2, my lord, what is the, my lord, status of the person concerned? Now, my lord, here your lordship has said I'm an unsuccessful resolution applicant. Now, my lord, here what happens is, my lord, 2 persons have given their bids. They have chosen the MSME, my lord, promoter, or, my lord, the person who is, my lord, backed by the MSME status of the corporate debtor as, my lord, the successful resolution applicant, although my offer was better.
No, but then that is pending consideration before NCLT.
No, my lord,
why will that be looked
no,
into?
my lord, I'm not asking your lordship. My lord, now, my lord, today, without the MSME certification, he is not even eligible. Now, my lord, we are, my lord, really on the eligibility of the candidate. And, my lord, your lordship has seen from the judgment of the NCLAT and the Supreme Court Justice Sanjeev Khanna's judgment of 2025 that, my lord, today the NCLT cannot go into this issue of whether it's a valid certificate.
Assuming NCLT cannot go into the issue,
right?
What right do you have to
Yes,
challenge?
my lord, let me now, my lord, show your lordship
Why
that
the
right.
writ petition will be maintainable at your instance?
Now, my lord, I'll tell your lordship exactly why. Now, my lord, today, if he was not, my lord, successful or he was ineligible, then, my lord, I would naturally, my lord, be considered because, my lord, my offer is not rejected as being, my lord, not maintainable or, my lord, being an ineligible applicant. They have, my lord, at best ranked me as number 2. My lord, consider a case of a tender where, my lord, the L1 tenderer, my lord, becomes ineligible, L2 tenderer, my lord, steps in. My lord, that is, my lord, the situation here. So, my lord, if his MSME registration is cancelled, naturally, my lord, I get it for entry into the door. This apart, my lord, even after that, if, my lord, the company is dissolved in the hands of an ineligible resolution applicant, and, my lord, here there's clear related party.
But then how are you bothered whether the company survives, it dies, it
my lord,
perishes?
my
It
lord,
doesn't matter
I
to
am
you.
bothered because, my lord, I am a stakeholder because I have, my lord, made a bid.
You have just merely made a bid.
My lord, my lord, here, my lord, your lordship will see, my lord, my learned friend, now, my lord, cites these judgments, but there are scores of judgments, my lord, where, my lord, plans have been cancelled because, my lord, the applicant was ineligible.
That is for the NCLT to decide.
My lord, no, my lord, so far as that is decided, in deciding that, my lord, the NCLT will see, is there an MSME certificate? They will say yes. Can you go into the validity of the MSME certificate? No. Who will go into that? The Supreme Court has said, I allow central bank to file a writ petition.
No, that is the central bank.
No.
The central bank
No,
was a secured creditor over there.
That may be so. But the question here is, today what is my status? My status is, kindly see the scheme of that. I am an UI, I have given my expression of interest. I have made my bid. My learned friends have not said that my bid was ineligible. They have said that they have chosen one over the other. Now, I am pointing out that you could not have chosen the one over the other because the other person was ineligible because the certification was
No,
wrong.
I understand. It is a double-prong attack. One before NCLT and one over here, the MSME certification.
Yes.
Right? This way, both sides you are attacking.
No, my lord. My lord, kindly see, my lord, what I am saying, my lord, there are scores of judgments. My lord, Mr. Banerjee now, my lord, hits at the locus, but my lord, there are scores of judgment where, my lord, we have, my lord, at the time of plan approval, repeatedly, my lord, assailed, my lord, the related party status, my lord, the MSME character, and my lord, other bars under the insolvency. And my lord, there, my lord, the tribunal takes into consideration. But my lord, the tribunal cannot take this matter into consideration for the simple reason because my lord, the Supreme Court has held.
Yes, that I have followed.
Now, my lord, the question of my locus comes in. My lord, today, if he goes out, I come in. And my lord, here, my lord, my learned friends have shown your lordship judgments. My lord, I am unfortunately, my lord, I have to, my lord, share this. My lord, may I just hand over to your lordship?
No, you can share the screen. Yes,
I will
yes.
try to do that. I'll try to do that.
Tell me what it is.
This is independent sugar judgment.
Well, this is the judgment of the Supreme Court.
Supreme Court, yes.
Supreme Court in the matter of independent sugar.
Hindustan National Gas.
Well, where, well, here, my lord, the question of an aggrieved party has been discussed. And my lord, the question of locus standi has been discussed, my lord, threadbare. My lord,
No, it's all right. You can continue. You can continue. You can continue. I can understand. Yes.
Well, this is what it says, objections as to locus standi. This is a discussion of the Supreme Court on the objections as to locus standi. It says at the outset, the preliminary objection regarding locus standi of the appellants to prefer the present appeal must be dealt with. Section 61 of the IBC provides a statutory framework for appeals against orders of the adjudicating authority, that is the NCLT, stipulating that any person aggrieved by any such order may prefer an appeal to the appellate authority. Further, Section 62 extends the right of appeal to Supreme Court. Similarly, Section 53B of the Competition Act provides that any enterprise or any person aggrieved within the statutory framework may file an appeal against any order of the CCI to the appellate tribunal. Then, my lord, please see, my lord, paragraph 26. Once the CIRP is initiated, the nature of the proceedings are no longer in personam, but rather become in rem. In light of the same, the expression any person aggrieved in the context of the IBC has been held to be indicative of there being no rigid locus requirements to institute an appeal challenging an order of the NCLT before the NCLT or an order of the NCLT before this court.
No, this is challenging the order of NCLT before NCLAT.
I'm not importing that concept because here this becomes an action in rem. I'll read on. In the present case, I'll just read this on. Paragraph 27. In the present case, the appellant, an unsuccessful resolution applicant whose resolution plan could have otherwise been approved by the COC, satisfies the requirement of being aggrieved. This preliminary locus standi objection vis-a-vis the appellant therefore does not merit acceptance.
I'm an unsuccessful resolution.
And I'll tell you, lordship, why. Today, at the end of the day, your lordship is trying to see as to whether ultimately a fraud has been practiced in collusion, in conjunction with the statutory authority, or simply on the basis of misdeclaration. Mr. Kaur has said that he is entitled to continue the MSME status without disclosing that it came to an end in 2022. 14 months gap before he applied for and obtained the fresh registration. He has to make a self-declaration. I'm sure the declaration is not that it is to be continued in status. He has said, this is my plant, this is my machinery, this is my turnover. That's a misstatement. That's a false statement. And my lord, as your lordship has heard, it is on the basis of a self-declaration that is made. And my lord, therefore, the self-declaration, if my lord fraudulently made by RP, who is acting as an officer of court, well, that has to be my lord countenanced somewhere. And my lord, since I cannot go and raise this objection before the NCLT because your lordships have seen the judgments, well, I have to raise it before your lordship. And my lord, here, prima facie, if I can show your lordship that yes, there is no basis on which this MSME certification could have been granted. It hits immediately at the eligibility of the respondent number 3 to my lord put in a plan for his plan to be taken under consideration, for his plan being approved. If that is not fraud on court, then I suppose the question, what is? If it is fraud on court, then everything can be unraveled. Your lordships have repeatedly, without exception, unraveled the entire fraud whenever your lordship has been confronted with a situation that's fraud on court. Now, why are my learned friends so vociferously defending the MSME status? Because without the MSME status, they are not eligible. That is something that I will raise before the NCLT related party clearly. What is there? Husband's family, the daughter's family, is the promoter of the company, which goes into insolvency. The daughter's marital family now wants to take it over. Clear case of related party. So they know that they can't succeed there. So MSME is what they're banking on. And MSME certification obtained after 14 months, no question of continuing bar under section 14, no question of a declaration being made, contrary to what the actual records show. And on that fraudulent basis, the declaration obtained. And who is pursuing this matter with such vigor? Is the resolution professional. The resolution professional has said, I am entitled to continue the status. When the status of MSME had come to an end in 2022, not disclosing, has the resolution applicant professional disclosed in the self-declaration that there's no electricity, no manufacturing, no trade, no transaction, no activity? I am therefore being deprived of my right to be a part of the resolution plan process on the basis of deliberate misdeclarations and false declarations. And so far as the question of locus is concerned, your lordships have now laid down a number of judgments that my locus arises not only when I'm actually aggrieved, but when I apprehend that I will be aggrieved by an act that is to follow. Now here my grievance is already real. It has matured. Because here my plan has not been considered, not because I'm ineligible, but at the cost of considering an ineligible plan. And that is where I stand. That is why your lordships have seen, maybe at the instance of the central bank, this is the judgment. We now have it on screen. I'm sorry.
No, you've read it. Yes. I have followed it.
They can now, so far as this is concerned, therefore, my learned friends have cited decisions which says, an unsuccessful resolution applicant cannot challenge the plan. Now, cannot challenge the plan when? Let me answer the question. If your lordship sees these judgments, your lordships have seen isolated paragraphs of the judgment, your lordship will see that my plan is better, your plan is not better. That is the challenge. So, therefore, I cannot go and bring that challenge before the adjudicating authority. Why? Because the law is, you cannot question the commercial sense or the commercial prudence of the committee of creditors. So, when they have said this plan is better than this plan, then the adjudicating authority says that no, the unsuccessful resolution applicant will not come forward and challenge the plan on that ground, because ultimately it is the commercial wisdom of the committee of creditors which is comprised of the secured financial creditors or financial creditors of the company. Not in a situation such as this. And that is why, your lordship has seen that the Supreme Court has said, in the course of an appeal, where ultimately it is in the context of the IBC, in the context of an unsuccessful resolution applicant. Today, if you have a the bar on your right is a perceived bar under the statute, under the act. The Supreme Court has said that no, you're a person aggrieved even if you're an unsuccessful resolution applicant. But it is on the facts of the case. It is not a general proposition. I can say with conviction that in every case, where the Supreme Court has said, or the NCLT has said, or the NCLT has said that no, an unsuccessful resolution application will not have locus to challenge the resolution plan. It is on a comparison of apples with apples, oranges with oranges. It is not in a case where a person is completely ineligible and has no right to apply in the first place. It is a fraud on court. Yes. Fraud on the authority. And fraud on the authority and fraud on court is something that will allow every person to go in, because it assumes the character of a action in rem. No longer an action in personam. So today the question is, today do I have an interest? That's the first question. I have an interest because I have put in a plan. Was I ineligible? Has my plan been rejected? No, it is on comparison with their plan, it has been rejected. I say that your plan could not have been considered, it's being fraudulently considered by the resolution plan professional acting in collusion with this particular MSME promoter's relative. saying that it still retains the MSME character, so I should be allowed to participate. When Malad, there's a clear statutory bar. It says only if it's MSME then. And Malad, MSME character, Malad, is not a permanent character. Once an MSME, almost an MSME, it's not the case. My learned friends have not explained that after 2022 until Malad, it was declared CRP and Malad, this was renewed. What happened? What was the status of MSME during that period?
The balance sheet says
nothing. The balance sheet says that it was not a going concern. The balance sheet says plant and machinery have not been verified. The balance sheet says that my lord, turnover was 48,000 rupees.
As on the commencement of CRP, it was not an MSME.
no.
It was not an MSME.
So on the commencement of the CRP,
when did the CIRP proceeding commence?
well, the CRP
22nd August 2020.
Date?
no, August when it commenced.
22nd August.
No, this commence is 22nd August 2023. That is when the order was passed, admitting into CRP.
That time they did.
Well, 22nd August 2023.
Yes.
MSME Malad certificate lapsed on 30th of June 2022. It was renewed on 25th August 2023, 2 days after the CIP commencement order. On the basis of a declaration made, Malad, the date on which the application is made, on that date the certificate is granted.
Where will you give me the citation of the judgment that you relied upon?
Yes, Malad. It operate log.
2025 SCC online SC 181.
2025 SCC online?
SC 181. Malad, the paragraph is 26, 27 of the relevant. 23 to 27.
And then 155 onwards, the plan of the unsuccessful resolution applicant was set aside.
And from page 155 on page
Para 155.
para 155 onwards, the plan of the successful resolution applicant was set aside.
And unsuccessful resolution plan was considered because of the.
And the plan of the unsuccessful resolution applicant was accepted.
Very
well. Sorry. I'm sorry, Mr. Court. Did you want to? I just want one submission. Approve this judgment only. When looks at the judgment, kindly look at paragraphs 23 onwards. And particularly paragraph 26, where will find what we have stated is exactly the proposition. All this within the IBC framework itself. The appeal was under section 62 of the Insolvency and Bankruptcy Code and section 53T of the Competition Act. Because my learned friend should also explain the issue there was that the Competition Commission had passed an order. There was an appeal against both orders.
With the unsuccessful resolution applicant?
No, in that context, in the IBC network, you can't have a roundabout way petition to challenge this.
One actual corrections, Lord, I want to be received, Lord, instructions from my client. Lord, MSME certificate renewal was applied for by the corporate data.
When?
Lord, prior to it.
May I?
Prior to?
Your Lordship, there is no question of renewal of MSME certification because since 2020, the MSME Act came into force. And since then, the MSME registration number, that is the Udyam registration number, that is a permanent registration number that cannot be cancelled.
No question of cancelling. Can it not lapse?
No, there is no question.
There is a certificate which mentions it's valid till such and such period.
Lordship, that certificate was issued in 2018 before the commencement of the Act of 2020. And after that, if your Lordship kindly takes up page number 253 of the writ petition, as well as 254, your Lordship, of the writ petition.
Yes.
Your Lordship, kindly note the date of filing of this certificate. That is 10/6/2020. This was after the commencement of the Act and no date of...
253 you said?
254, your Lordship.
254?
Yes, your Lordship. In this certificate,
date of
filing is 10/6/2020. That is the this is after the commencement of the Act of MSME. And no date of lapse has been mentioned in this. There is no date of lapse. And if your Lordship kindly comes to our instructions, page number 3, your Lordship.
Well, then why was it reapplied? Why was it granted again?
Lord, I couldn't complete my sentence because my let her complete, then I'll make my submission.
Page 3.
page 3, Your Lordship. This is section
company is
2,
also different.
subsection 2.
Yes.
On registration and enterprise referred to as Udyam in the Udyam registration portal will be assigned a permanent identity number to be known as Udyam registration number. Kindly now come to the page 254 of the writ petition. This has been mentioned as Udyog Aadhar. Before the commencement of this act, Udyam was not there. This is the Udyog Aadhar, and all the MSME enterprises, they were given extensions to reapply, re-register themselves under
As
the
Udyam.
Yes. So this Udyog Aadhar was before that. Thereafter, only then a re-registration had to be made under the Udyam, and that had been done by the
So, according to you, there is no lapsing of the status
lapse, Your
once
Lordship.
MSME continues for MSME
Yes, Your Lordship.
under the MSME Act of
Yes, Your Lordship.
2020.
Now, Your Lordship kindly comes to page number 5 of my instruction.
Yes.
That is section 9, subsection 4. This is the process that we have followed. In case of any discrepancy or complaint, the general manager of the district industry center of the concerned district shall undertake an inquiry for verification of the details of the Udyam registration submitted by the enterprise, and thereafter forward the matter with the necessary remarks to the director or commissioner of industry secretary concerned of the state government, who, after issuing a notice to the enterprise and after giving an opportunity to present its case, and based on the findings, may amend the details or recommend to the Ministry of Micro, Small and Medium Industries, Government of India, for cancellation of the Udyam registration certificate. This is what we have done. And as for the re-registration, the details had to be updated by the applicant themselves. That had to be a self-declaration. And that has been, Your Lordship, mentioned in page number. That is the registration process is section 6, Your Lordship. That is page number 4.
Yes.
The form of registration shall be provided in the Udyam registration portal. There will be no fee for filing. Aadhaar number shall be required for Udyam registration. Aadhaar number shall be for the proprietor. And thereafter, Your Lordship, number 6, point number 6, in case an enterprise is duly registered as an Udyam with PAN, any deficiency or information in previous years when it did not have a PAN shall be filled up on the basis of self-declaration basis.
That's what our case. Yes.
So these have been done by the respondent number 2. They did everything, and on basis of their self-declaration, we provided the re-registration as the Udyam Aadhar. And that there was no lapse. There is no question of lapse, because since 2020, that serial number that is provided, that Aadhaar number, that is a permanent number. Only the DFO can make amend or change or apply or give or cancel, Your Lordship.
Lord,
Yes.
just one sentence with that. Lord, as on the date, when Lord the resolution professional Lord took over, Lord, it was a going concern, because Lord, it had two plants. One is a steel plant, the other is a cement unit. The disconnection of electricity took place in the steel unit, but the cement unit was functional when he took over the possession of the assets. Now, Lord, this is one other fact which I wanted to bring on record, because, Lord, I received the instructions lead. Factually, Lord, this is exactly what had happened. I wanted to say exactly what she said, that, Lord, it was just the changeover for which, Lord, the corporate debtor had applied. And the changeover was recorded, registered, and then, Lord, it was received by the resolution professional, because by that time, the resolution professional had come into possession of the assets.
Very well.
My learned friend says that there is no need for a changeover. Because the Act says once you are registered as an MSME, you are forever registered as an MSME. That is the contention.
No. Till your certificate is cancelled.
My learned friend herself says that you need to re-register. The re-register needs, what my learned friend said, a self-declaration. Now, if the declaration does not match the criteria, then naturally it will not be re-registered. It has to ultimately satisfy the classification. Now, so far as declaration is concerned, my learned friend will then have to make a declaration. I've shown you, Lordship, the balance sheet. Cement plant functioning, my learned friend says, he took over as a going concern. He says, total turnover is 48,000 rupees. That's number one. Number two, so far my learned friend says, self-declaration, then one has to see what is the self-declaration made which prompted The authority is to accept the declaration to be true and correct and to re-register. Third is, my lord, if your lordship now sees the, my lord, certificate of re-registration, my lord, that has been shown to your lordship. Kindly see. My lord, this is, my lord, page 295. My lord, kindly see the date of classification. My lord, the certificate is dated 25th August 2023. That's at page 2, my lord, 95. Date of certification is, my lord, 25th August 2023. Just above that. Date of commencement of production is 5th June 2021, 2001. And then, my lord, kindly see the top of the page. The classification, serial number 1, 2425. Medium classification date is 27th April 2024. Much, my lord, after the certificate itself is granted. It's a future date. Because the certificate is a 2023 certificate. And, my lord, then, please see, 23rd.
Which page are you referring to?
Page 295.
295. Well, 295.
It is date of registration is 25th of August 23.
That's right. And well, kindly see over that the classification date.
Classification date at the top.
24.
27th of April 24.
Well, a future classification is being made.
And from small, they have turned into a medium.
And well, it was initially a small scale enterprise. That was the certification. Now it is a medium. Now, well, all that I'm saying, well, here is, well, so far as this is concerned, well, this registration, well, even if the authorities have proceeded, well, on the basis of a declaration, well, the declaration made by, well, the resolution professional was completely fraudulent.
All right.
Your Lordship, there is a small
And,
correction.
Your Lordship has seen the report. This makes it clear.
Your Lordship, I have just been informed that the re-registration that is done automatically. The applicant does not need to do it themselves. That is done automatically. And Your Lordship,
Self-declaration not required.
Self-declaration that was in the previously that they had already submitted. They had already a Uddog Aadhaar number. Uddog Aadhaar was already there, Your Lordship. There they had to make a self-declaration. That was based on their self-declaration. And after that, when they became Udyam
From Uddog to Udyam, there is nothing to be done, and it will be done automatically.
Automatically, yes, Your Lordship. That is to be done automatically.
Like mortgage, once a mortgage, always a mortgage. Once an MSME, always an MSME.
The registration number is also changed.
Even if you don't have business, even
At
if you
least,
don't have
but,
plant and machinery, if you don't have turnover,
for the procedural issues,
Just inquire from your client what is to be done for the purpose of cancellation of this certificate. Who has to apply? How is it applied?
Your Lordship, cancellation is done only by the DFO on the basis of a complaint that has been received on their end. That
complaint made by anybody?
Yes, Your Lordship. Yes. Any complaint.
Under what is the section? Please tell me.
Your Lordship, 9. Section 9. Subsection 4. That is the procedure. Page number 5, Your Lordship.
Yes. Facilitation and grievance redressal of enterprises.
Yes, Your Lordship. No. 2020.
2020. This 2020 Act. Act or rules?
No, it is
Act.
2025 rules and regulations.
This is the only change. This is the only change. I have it. Your Lordship, section 9, subsection 4. Page number 5. That is the process. In any case of
discrepancy or complaint, you mean to say complaint can be lodged by anybody?
Yes, Your Lordship.
Anybody under the sun can come and lodge a complaint against XYZ MSME?
There's a bidder who is
Any unit, Your Lordship. Any MSME registered unit or any company. Any company, Your Lordship. There is no.
If that be so, then your entire submission of locus standi just fails.
That's what I was
But, there are two aspects. One,
nothing. The submission that has been made just
And my lord,
end of the entire 1.5 hours is that anybody can come up with a complaint and there is no concept of locus standi.
there's no classification, my lord.
let us.
And my lord, one more thing, my lord, for proper adjudication of the matter, the Union of India, my lord, the government of India should be added as a party, my lord.
Lord, the fact that complaint can be entertained, that's one aspect of the matter. But Lord, this is and Lord, this certificate was continuing as on the date, Lord, it was this declaration had come.
Assuming.
Then not if it had come, if this protection of the act is there, then question of considering this complaint does not arise, because Lord, if this complaint, Lord, is at the instance of an unsuccessful resolution applicant who is making a complaint post.
Just now the submission was anybody can come and make a complaint. So whether he's an unsuccessful resolution applicant or not hardly matters.
The addition is that unsuccessful resolution applicant is aware about the provisions of the act.
The act will be there, certainly.
Kindly, my lord, see section 9 once. I'm grateful. Kindly, my lord, have a look at that section 9. My learned friend was relying.
Yes.
Oh, I'm sorry, rule 9. This is, Lord, 2020, rule 9.
Yes.
Says 3. Any person who's not able to file Udayan registration for any reasons, including for lack of Aadhaar number, may approach any of the above single window system for Udayan.
That is different. That is absolutely different.
And 4, kindly see.
Yes.
In case of any discrepancy or complaint, the
Complaint.
Now, Lord, who can reading this out of the context is Lord giving an interpretation to a rule, Lord, going beyond the provisions. Because 3 and
there is no classification at all.
There has to be something to say that where from the complaint can come.
The discrepancy.
We are not going into the IBC at all. It is only the issue that has been portrayed
This complaint is only for the purpose of verification. This complaint is, kindly see,
yes,
it's only for the purpose of verification.
Verification as to whether you are MSME or not.
No, verification, kindly will not see, it says, the verification of the details of Udom registration submitted by the enterprise, and thereafter forward the matter with necessary remarks to the director or commissioner of industry, secretary, etc. This is inquiry with regard to the declaration.
This is what he says. You've made false declaration.
Declaration, that is the issue. Whether they can go into this in the teeth of section 14 of the IBC at this stage.
That is your protection that you enjoy. That is the protection that you enjoy, the moratorium period.
Lord, the question is, Lord, if an inquiry is launched today in the teeth of section 14, knowing fully well that the 14 is protecting, Lord, I don't know, Lord, what would be the conclusion?
How will the authority know whether you are under any moratorium or not? The authority is not supposed to know.
This fact has to be disclosed to the authority.
Certainly.
So once these facts are disclosed, the authority can't get into it.
Then that is a different thing. Let the authority take a call. Why was I hearing the matter for so long? Come. The petitioner is an unsuccessful resolution applicant who challenges the status of the respondent number 2.
May I have pilot's time, please?
Yes. A lot of time has been consumed from 10:30 in the morning till
not by me. I can tell you.
By the court, the whole proceeding. I'm not blaming you, not at all. Don't take it that way, please. No.
It was just said in
No.
It's all because of Mr. Shah.
Resolution applicant who challenges the status of the respondent number 2
as an MSME. Stop. A complaint was lodged before the director of MSME in February 2025, and the same is alleged to be kept pending. Stop paragraph. The learned advocate representing the state respondents has placed before this court an inspection report of the respondent number 2, signed by the general manager, District Industries Center, Paschim Bardhaman, dated 3rd April 2025, disclosing that on inspection it was revealed that the unit has been closed for some years. Stop. All the machineries have been dismantled and no employee/worker was available in the unit premises. Stop. Paragraph. From the documents annexed to the writ petition, it appears that the respondent number 2 was granted an MSME registration in July 2018. The said registration was under the Udyog. What is the term? Udyog?
Udyog Aadhar.
Udyog Aadhar.
Yes, Aadhar registration.
Stop. After coming into force of the a notification of the Ministry of Micro, Small and Medium Enterprises on 26th June 2020, the company was registered under the Udyam registration. Registration on 25th August 2023. In the meantime, the respondent number 2 was admitted into CIRP under the Insolvency and Bankruptcy Code, 2016. Stop. Paragraph. The petitioner contends that the respondent number 2 could not, respondent number 2 cannot enjoy the status of MSME as the unit of the respondent number 2 was not operational on the day the MSME certification under the Udyam registration was made. Next. Prayer has been made for cancellation of the MSME registration. Paragraph. The respondent numbers 2 and 3 raises an objection with regard to the locus standi of the petitioner in challenging the MSME status of the petitioner. Stop. Decisions of the Honorable Supreme Court have been relied upon in support of the submission that an unsuccessful resolution applicant cannot challenge the MSME registration of the unit.
Cannot challenge the resolution plan. Not the
Cannot
MSME.
challenge the resolution plan submitted by the resolution submitted by the resolution applicant. Resolution applicant. Stop. Paragraph. It further appears that there are proceedings in between the parties pending before the National Company Law Tribunal. Stop. Paragraph. The instant writ petition only revolves around the status of MSME of the respondent number 2. Stop. Paragraph. The inspection report forwarded by the General Manager, District Industries Center. The inspection report of the General Manager, District Industries Center, dated 3rd April 2025, appears to have been forwarded to the Assistant Director in Charge, MSME DFO, Durgapur, for necessary information. Stop. Paragraph. Rule 9 of the
Rule 9, clause 4.
Rule 9 within bracket 4. Acha, rule hobe na. This will be the clause 9 within bracket 4 of the notification of the Ministry of Micro, Small and Medium Enterprises dated 26th June 2020 mentions that in case of any discrepancy or complaint, the general manager of the district industries center of the concerned district shall undertake an inquiry for verification of the details of Udyam registration submitted by the enterprise and thereafter forward the matter with necessary remarks to the director or commissioner or industry secretary concerned of the state government, who, after issuing a notice to the enterprise and after giving an opportunity to present its case and based on the findings, may amend the details or recommend to the Ministry of Micro, Small or Medium Enterprises, Government of India for cancellation of the Udyam registration certificate. Paragraph. The aforesaid provision mentions about a complaint before the general manager. Stop. In the instant case, a complaint is already on record and a spot inspection has been conducted. Stop. The general manager, District Industries Center, is directed to follow up the matter strictly in accordance with the aforesaid provision and conclude the same at the earliest.
Your ladyship, I'm appearing for the resolution professional. So your ladyship may give us the liberty to file our representation before the competent authority.
This is already there in the law that you will be heard. It says that it has to be given an opportunity to present its case. So you will certainly be given an opportunity of hearing.
Oblige your ladyship.
It's not that without hearing you, they are going to pass any order. They will certainly give you an opportunity of hearing. একটা line একটু hand up করে দিন. As the provision mentions about an opportunity of hearing to be granted to the enterprise, steps shall be taken strictly in accordance with the same.
And your ladyship, all points should be open in law before the DIC, your ladyship.
All points open. Nobody is restricting any of your points, your moratorium point,
Ladyship,
every point.
I am a court appointed officer, so I also
Right,
have a stand.
You will have your stand.
Meantime, let them not rely on this registration.
No.
Oblige, my lord.
জাজমেন্ট স্কুলে ফেরত দিয়ে দিন, প্রচুর মোটা মোটা স্টেটের গুলো থাকবে, ফটো সব ফেরত. I have not referred to anything, so it's no use holding back all these documents. এইটা থাকবে আর স্টেটের কাগজটা থাকবে. ওইটা লিখে নেবেন কিন্তু যে রিপোর্ট অফ দি, এটা তো দিয়েছি, তার সঙ্গে সাপোর্টিং ডকুমেন্টস রিটেন উইথ দ্য রেকর্ডস.
Lordship will fix a time within which this decision.
At the earliest I have mentioned.
Very.
কে কোনটা দিয়েছে আমি উপরে লিখে রেখে দিয়েছি. এটা স্টেটের. হ্যাঁ, ও দুটো থাকবে.
স্টেটাস এর কপিটা দিয়েছে? হ্যাঁ, দিয়েছে। সেটা ইউজ করো, সেটা রিলাই অন দিস.
Return the book, please. Don't call any other book. ডিভি বাবু, ও ডিভি বাবু, আজকের আইটেম 109 grievance redressed. Yes.
My lord, appearing on behalf of the petitioner, my learned senior Shishana Bandyopadhyay is in the matter, my lord. Before, my lord, I seek further time, my lord. I seek accommodation for the day, my lord. We have already intimated the respondents, my lord, on this, my lord. Kindly, my lord, the status, my lord, is that we
It has
had
come at your instance, isn't it?
Yes, your lordship, I actually mentioned this matter. My
Yes.
lord, learned ASG is appearing in this matter, and if accommodation is sought for, then learned ASG is actually appearing in court number 8. So
Not today?
Lordship, if it is not today, then kindly fix it after 7th, because on 7th I will not be here.
one submission, my lord, if
On
I seek
8th,
indulgence,
if
my
it
lord.
is taken as urgent motion.
8th?
8th, your lordship.
One submission, my lord. We actually were asked to attend a hearing, my lord, on 7/3/2025, my lord. So we actually seek, my lord, if there is a copy of the result of the outcome of the, decision that has been
Let me
taken.
see.
I mean, that is
Lordship,
handed over to us, my
kindly
lord.
pass over the matter so that learned ASG can come and appear. Lordship,
But
a short
actually,
pass
my
over
lord,
will suffice.
my
your lordship.
senior.
Did the hearing take place?
Yes, your lordship.
Yes, my lord, it did actually.
Hearing took
Yes, my
place.
lord. But my senior, my lord, might have to something to reply on that, my lord, and apprise the court and address
Very
the
well.
court as well.
Accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. On such prayer, list on 8th of April.
Lordship, in same position if it is.
Yes, yes, urgent motion.
Grateful, my lord.
It is will come.
Okay, my lord.
Made, please, your lordship, my lord. Lord, this is a tender with regard to construction of road. Lord, kindly take page 29 first.
Well, I am for the interview.
Intervener.
I am also the intervener. I am selected and
Lord, financial bid has been opened yesterday.
Selected work order issued when?
Today work order has been issued.
Today, that's why I mentioned
And
yesterday.
21st March technical bid, he was rejected. After 21st March, he comes on 26 before this honorable court.
Lord, supplementary.
Thereafter, financial bid opened. Thereafter, LOA, letter of acceptance given. Today work order has been.
Lord, financial bid open on 28th of March. Work order is sought to be issued today. Lord, I have a very limited point before your lordship. Lord, kindly take page 29 first. I have prepared a supplementary affidavit annexing those documents. Take page 29 first.
29?
Yes, of the writ petition.
Yes.
Lord, 29, my lord, will find, Lord, a list. Or, sorry, not 29, kindly come to 23. I'm so sorry, 23.
Yes, a list.
Yes. Lord, there are 20.
This is the notice inviting
Yes,
tender.
29, for 29 work, the tender was issued. Kindly come to page 29.
Hmm.
I applied for, Lord, serial number 26 and 28.
All right.
Lord, these two are mixed seal surfacing work. Why I say mixed seal surfacing work? Lord, that will be a little important. Kindly come to page 57, the qualifying criteria of the tender.
What you said? What type of work?
Lord,
Mixing?
I have annexed the BOQ. From BOQ, it will appear. This is a MSS work, mixed seal surfacing work. These 26 and 28, these are mixed seal surfacing work, which comes under category B. I'll take your lordships there. Kindly come to page 57. The qualify.
What is the illegality?
Illegality is, my lord, they have rejected my technical bid on the ground that I don't have machinery and manpower. I have annexed documents which I have more than what is required. To take you to category B, I said.
Did you lodge complaint before the authority?
No. Lord, it is rejected. I came to your lordship's court.
Why? Will you not approach the authority?
Lord,
That
the authority
this is the problem.
after rejection of technical bid,
Yes.
they have rejected my technical bid that I don't qualify. Thereafter, they opened the financial bid. Now they are going to issue the work order.
Obviously,
The entire exercise is perverse and, my lord, arbitrary. I am here to point out that to your lordship.
You ought to have approached the authority first and
But
drawn
the
their
authority did not
attention.
consider the documents available to them.
You should
and
have brought
rejected
it to their notice.
Lord,
Sorry,
kindly
sir,
seize
it
the
cannot be
document
done
once.
now.
Kindly seize the document
No,
once.
the court is not
Lord,
the authority to
Lord,
see.
let them show the provision that after the technical bit is rejected, I can go and tell them that you
Clause 22.6.
Page.
So that
Page.
Lordship kindly comes to page 67 of volume 1.
Page 67.
It is with your lordships. With your lordship.
Yes.
It is volume 1, page 67. 57. Kindly sees 22.6.
That is the bid opening.
The result of the
technical bid
evaluation
after
shall be
opening,
made
yes.
public, such as the following the 5 working day. Any bidder may say yes.
My lord.
See, you have a provision to
The employer inviting the bids of the authority representative will open the bid. Yes, 22.6. The result of evaluation of part 1 of the bid shall be made public and e-procurement system, following which there will be a period of 5 working days during which any bidder may submit complaint, which shall be considered and resolution before opening part 2. But after
Part 1 is what?
Part 1 is
Technical.
technical bid.
Kindly see page 43.
After they rejected my technical bid, I came to your lordship's court.
Why? The
Lord,
provision
challenging
is
that they have not
Sorry,
considered
sir,
that.
please
Lord,
stop.
kindly appreciate. Lord, kindly
No, sir,
take the
nothing to
document.
appreciate.
Lord,
Please
kindly
come.
take the document once. Lord, it
Now
was available to them.
The petitioner is
Lord,
aggrieved
kindly
by
hear me for 2 minutes.
cancellation
Then you also rejected. Kindly hear my
of
submissions.
the technical
Lord, kindly
bid.
hear my submissions.
Stop.
My Lord, kindly see that.
The
I
petitioner
got to know, Lord, after 5
participated
days.
in
Lord, I got
response
to
to
know
a
after 5 days. Lord,
notice
kindly see the document once.
inviting tender
P92. My Lord, will
dated
not hear.
6th
My Lord, will
January
kindly hear me for a minute. Then
2025,
reject the matter. Kindly hear me for a minute.
published
Lord.
by the West Bengal State Rural Development Agency. Stop. The petitioner submitted his bid in respect of serial numbers 26 and 28. Stop. The petitioner submits that the bid, his bid was illegally and arbitrarily rejected. Stop. The petitioner rushed to the court without approaching the authority. Stop. Paragraph. It has been brought to the notice of the court that today, আজকের তারিখটা দিয়ে দেবেন, 4th April 2025, work order has already been issued in favor of the successful bidder. paragraph.
Work order, Lordship.
From the notice inviting tender, it appears that clause 22.6 clearly mentions that the result of evaluation of part 1 within bracket technical bid shall be made public on e-procurement systems, following which there will be a period of 5 working days during which any bidder may submit complaint which shall be considered for resolution before opening part 2 within bracket financial bid. Stop paragraph. It appears that in the instant case, the petitioner did not avail the remedy that is already mentioned in the notice inviting tender. Stop. The petitioner, prior to moving the writ petition, ought to have approached the authority with his grievances. Stop paragraph. At this stage, the court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. The instruction forwarded.
I have respectfully handed over
by
a work
the,
order.
Executive Engineer,
Work order.
WB SRDA Murshidabad Division, annexing the work order.
No, Lordship. No, this is the instruction and work order is separate. It has come later on.
It's the work order. It's mentioned.
Yes, only work order, but instruction is separate, is there, Lordship.
Instruction you can keep also.
Lordship,
Or you
kindly
can-
see the entire this
the work order?
factual aspect is there. Kindly see the first page, Lordship.
Work order.
Date of technical bid
instruction আছে, work order
uploading
রয়েছে।
21st.
Written with the records. Supplementary affidavit. Supplementary affidavit written with the records. Yes,
Lord,
next.
they have not considered the available document. I will not consider that just because I did not approach them, my writ will not be maintainable.
Yes, sir.
May I have a copy of the work order, Miller, so that I can?
No, somebody else's work order. Why will you obtain under the Right to Information Act?
Very well. Grateful.
Item number 4. Please.
Sir, I appear on behalf of the respondent number 6.
Lord, I am appearing for the petitioner, Malad, in this matter, Malad. Malad, I am led by Mr. Mithro, Malad.
Yes.
Malad, due to some personal difficulty, Malad, he is not in the town, Malad. I am only beseeching, Malad, may this matter be taken up, Malad, on Monday, Malad.
Urgent matters will not be adjourned. You please proceed.
But if your Lordship kindly comes to page 24, Malad, of the writ petition.
Yes.
Malad, this is the order of Malad, Honorable Justice Shobhashachi Bhattacharya, Malad.
Yes.
Same nature of work, Malad, passed in 2020, Malad. Malad, page 3, internal page 3, Malad, page 24, Malad, the order, Malad. Even looking into the cancellation or termination clause of the contract in question, although it is mentioned that the respondent authorities can terminate such contract without assigning any reasons, the said termination clause is in effect qualified by 2 factors. A 7 days notice has been served for such termination, and unsatisfactory performance of the agency has to be observed by the controlling officer. Malad, this 2 point has not been given, Malad. Neither Malad, the 7-day notice has been given, Malad, or Malad, even they have said that yes, your
what has happened?
Malad, happened, Malad, that
you are in a
Malad, I am
contract.
working since 2015, Malad.
All right.
Malad, my extension, further extension is going on, Malad.
All right.
Malad, my last extension was, Malad, till 31st of March 2025, Malad. And they have floated the tender, Malad, before that, Malad, before my extension period, Malad. Malad, if your Lordship kindly comes to, Malad, the supplementary affidavit, Malad.
Lord, no copy has been served upon.
Malad, because on the last occasion he was not appearing, Malad. That's
If
why,
he was not appearing, you ought to have
But
served the party directly.
Malad, if your Lordship kindly comes to paragraph 7 of the supplementary affidavit, Malad.
What is there?
I say that similar circumstance writ petitioner had filed writ petition being WPA number 1669 of 2020.
report this honorable court upon hearing his lordship.
This is what the judgment that you relied upon.
My lord, to issue the work order against the third party, and ultimately in terms of order of honorable court, WBSEDCL has cancelled the tender, my lord. That cancel was that tender was cancelled, my lord. And more so, my lord, if your lordship kindly comes to the annexure, my lord, page 4, my lord. My lord, maintenance of 11 kV and LT lines and its installation, air conditioning equipment, intercommunication system, operation and maintenance of water supply system, including water pumps, motors, starters, valves, operation and maintenance of PG set and new guest house. This is, my lord, the work nature of the work, my lord. And if I lordship kindly compare this with the present tender process, my lord, that is at page.
It is at page 18.
My lord, page 18 is the 30th January 2025 tender, my lord. My lord, maintenance of 11 kV and LT lines and its related.
You can also apply. Who is stopping you from applying?
Tender process, my lord.
Yes.
But my lord, my extension period was, my lord, last extension date was, my lord.
Can you claim extension as a matter of right?
No, my lord, I have not taken as a right, my lord. But my lord, I am working since that, my lord, and my lord, several, my lord, too much. There was a due of rupees 1 crore 23 lakh and odd, my lord. And in the year 2022, I preferred a writ petition, and after that, my lord, they are behind me, my lord, and they are continuously, my lord.
Why do you intend to continue serving this authority who doesn't pay you your bills?
My lord, that was paid by the honorable coordinate bench, my lord, passed the order. That after that they paid, my lord. After that, my lord, I am
Again
only,
you have to come
no,
to court
my lord,
for
I am harping on
your...
I am harping on two things, my lord. One is that is page, my lord. Page, my lord, 24 of the writ petition, my lord. That is, my lord, kindly see, my lord, they have not given a notice to us, my lord. Neither they have given a the letter that your work is unsatisfactory or something, my lord. And they have floated
There is
the
no
tender.
question of that. Show me the contract that is being you are holding. Where is the provision for extension? Please show me.
My lord, page 16, my lord.
Yes.
But first extension order in respect of work for
No, not
maintenance.
extension. You show me that the there is a scope for extension. Show
But
me
my
that.
lord, they have extended, my lord. This is the extension order, my lord, that their WBSEDCL has extended, my lord, till.
They'll go on extending. How can that be?
But my lord,
the work will never come to an end.
My lord, but my lord, in the year, my lord, in January, my lord, they have floated the tent. They should have waited till, my lord, at least my extension order, my lord, when it is expiring, my lord.
Why will this extension be given to you? What was the requirement of an extension? A contract is for a particular period.
My lord.
Certainly, you may have not completed the work within the
No, my lord,
time
but
period.
they should have given me the letter, my lord, that objection. I have raised objection, my lord. Kindly comes to page.
You show me that you have got the right of extension. Please show me that provision.
That contract, it is not, my lord, annex, my lord. If your lordship so pleases, my lord, I will, my lord, on Monday, my lord, I am bringing that, my lord.
Yes. What is your...
Lord, may I submit?
Yes.
But he is the private respondent.
Lord,
So
you participated in the tender process.
He also participated in the tender. I also
have
participated.
submitted that.
There were 4 contestants, among which I have been selected as the lowest bidder, L1, and he is the L2. Now, what happens, my lord? Your lordship will kindly see the nature of job.
Yes.
It is a maintenance work of the electricity supply of the Purulia pumping station and also supply of the waters to the guest house and the quarters of the employees. Milord, it cannot be stalled, milord, at any point of time. Now, when your lordship will kindly come to page 16, it specifically states that it was extended up to 31st of March 2025.
Yes.
Now, after the expiry of the period, if the tender process starts, milord, in the intermittent period, there will be no water supply, no electricity connection, no generation. Milord, so for the purpose of continuity of the maintenance work, milord, it has to be
prior
to expiry. Milord, that's what has happened over
No,
here.
that is all right. No difficulty. Yes. Does the petitioner have any right to be extended?
No. Because if he continues there, then there will be total topsy-turvy. His life is expired. He's no longer is there.
we have appointed him and he is doing his job, continuing his job, entire project, not a simple place. So, my lord, I request your lordship, please don't disturb. They should not
Private
be
respondent.
disturbed.
Yes.
Please.
Only one thing, my lord. I'll bring the contract. My lord, your lordship, kindly keep this matter on Monday, my lord. I'll bring the contract, my lord. I'll show the your lordship, my lord. Kindly, my lord. Only 1 day accommodation I am asking for, my lord.
You are already out. Today is 4th of April.
But my lord,
He
from
has started
since
from
my
the first.
learned senior friend has said, my lord, that extension can be granted right now. But my lord, since 2015, they are granting me extension from time to time, my lord.
And so you've got
No,
a
my lord,
vested right to be
I am not
extended.
taking as a matter of
What?
right, my lord. But your lordship may kindly give us 1 day time, my lord. I will on Monday, my lord. I will show you the your lordship the contract, my lord.
Please come.
Deeply obliged.
Had submission made on behalf of all the parties. Stop. The petitioner is aggrieved by the Act of the West Bengal State Electricity Distribution Company Limited in floating NIET on 30th January 2025. Stop. The petitioner was the existing contractor and he submits that the authority ought to have extended his contract instead of floating fresh tender. Stop. Paragraph. From the documents annexed to the writ petition, it appears that the contract of the petitioner was valid till 31st March 2025. Stop. The nature of work requires maintenance of the electrical installations of all the buildings, including the guest house and the office buildings occupied by Purulia Pumped Storage Project Site and Turga Pumped Storage Project Site. Stop. For the purpose of maintaining the continuity of the service that is required to be provided by the contractor, the distribution company limited floated tender during the pendency of the contract of the petitioner.
And
Stop.
sorry to interrupt, my lord. And he joined. He joined.
The petitioner participated in the tender process and emerged as L2 bidder. Stop. The authority has already issued contract in favor of the L1 bidder, and the L1 bidder is right now performing the work. Stop. Learned advocate for the petitioner, paragraph diye, seeks accommodation to place on record documents in support of the submission that the petitioner has a right to be extended. Stop. On such prayer, relist the matter on 11th of April.
Deeply obliged.
Next Friday.
Deeply obliged.
Lord, let there be a direction for supplying me the supplementary affidavit.
Yes, certainly.
My lord, in the course of the day, my lord.
Supplementary affidavit. When did you file it? When did you?
My lord, on my lord.
Last day.
My lord,
Last.
my lord, on second, my lord.
Answer this. A copy of the supplementary affidavit shall be served upon the learned advocate representing the private respondents. Did you file your wakalatnama?
Miller, I'm filing. Miller, just now I have got the brief.
Okay, please do.
Deeply obliged.
Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, what happened, Lordship? I am the contractor, Lordship.
Who is your other side?
Lordship, I have served, Lordship. They have received, I think.
Union of India? Miss Pandey, are you there? Union of India. Chittaranjan Locomotives, who appears?
Appeared in other matter, I'll inform them, Your Lordship.
Chitonjo Locomotive is the main respondent, Lordship.
Yes.
Lordship, I have served, Lordship. I think yesterday they have received this. First March, Lordship.
Because in 1 day they not be able to appoint.
Next, I'll make
Monday.
it not today, Monday, it will be there in the list.
Lordship, under same heading, Lordship.
Same heading, it will be there.
March away.
None appears on behalf of the respondents. Released on Monday. Affidavit of service is taken on record.
I appear for the petitioner in
Lordship, Lordship, I appear on for the petition in item number 6. Your Lordship, this matter has been specially assigned to your Lordship because the connected matters are already before your Lordship. Lordship, today the interim order is expiring. My limited prayer is that the interim order be extended and kept with the other matters.
All right, let me hear once.
Lordship.
Lordship, in item 6, I appear for respondent 7, 8, and 9, Central Pollution Control Board.
All right.
Before my learned friend submits anything, Lordship, on several occasions, my learned senior friend will also perhaps submit the same thing, that no notice was served and interim order was extended. In item number 6, Lordship, Sanjay Shingo. 27729.
See, this matter has been assigned only day before yesterday before this bench, so I do not know what the interim order is.
Justice Ajay Kumar Gupta, Lordship, no notice was served upon the respondent. An extension was sought.
Lordship, the matter was appearing in the regular course in the list. I do not think a notice was required. And your Lordship,
It was there in the list.
Lordship, but they had mentioned because on the last occasion, 21st
March.
was a full court reference, and the item number was 170. Sorry. It was 179.
Yes.
So no notice they had mentioned because we were watching the board. 179.
Watching the board and not the court. You should be there in court and not stay in front of the board.
But
not stay in front of the board.
No, should be in court also. Go and stay in front of court. No, you go. Please go.
Forgotten your Lordship's days this side.
No, not at all. Yes. What is it? You want extension?
Yes, the interim.
I am opposing. I am opposing.
All right.
Kindly this is a question of absolute unauthorized construction of hotels in the vicinity of river and Mandalmoni. Environmental questions are involved. Kindly fix a date for disposal of this matter. The Central Pollution Control Board, I understand they have filed an affidavit.
All right. In 6. What about the others?
Lordship, 7 and 8, the interim order is there till 30th of April.
7 and 8.
Any affidavit from your side?
Milord, in item number 7, Milord, that is Mandalmoni Hotels Association. Milord, I am led by Mr. Kollan Bandyopadhyay. Milord, he requested that if the matter can be taken up on Monday or any day.
Monday? Hearing matter? I will be very happy.
But I appear for the state pollution control. Item number 6, my affidavit is ready. Have to make a copy and submit. Lordship will, as my learned senior friend.
You are appearing for the State Pollution Board. Your affidavit is ready.
Item number 6, it is ready.
All right.
But, as my learned senior friend submitted, if your Lordship fixes any date, I shall file it.
Insofar as item number.
Ready, file it now.
But I have to make a copy. The only original is with my.
Insofar as item number 8 is concerned, Milord, we have used an exception to the report file on behalf of the respondent numbers 22 to 25.
Who are they?
Additional district.
State authorities. All right. And what about the union in 7 and 8?
Affidavit insofar as
Central Pollution Control Board also not used anything.
7 I have used. It's already on record.
7.
Central.
No, the respondent.
7, 8?
8, Lordship, I'm not appearing.
7?
6 and 7 is already filed.
Insofar as 8, no
6 is a new matter assigned, so I am not aware.
Insofar as 8 is concerned, no affidavit from the unions, from any of the authorities. What we have only received is a state's affidavit to which we have responded. I am seeking a lot.
Milord, in item number 7, Milord, there are two reports and one affidavit in opposition.
From the state side.
From the.
Is there anything from the unions or central government side? I was looking for y'all. If nobody comes forward, what can be done? Please file your documents, your affidavits. What is your stand? The court is not aware of anything. On the contrary, The state authorities say that there is no map. What can the court do? The court did. Somebody has to come and say that there is a map.
10 minutes back, Miller, we received the construction, Miller, I submitted Miller within 10 days.
Within 10 days.
My
Lord,
learned
on
friend is
behalf
appearing
of the
in which
Central
matter, sir?
Pollution Control Board, my lord, they have used
Kon
an
mamla,
affidavit.
kon
We have filed a reply also.
7.
Fix the date, let the meeting, let all the in item number 7, my lord, that is.
Yes, when can the date be fixed? 10 days time has been sought for.
Well,
The interim order is there till 30th of April.
Yes.
I think, Miller, the interim order be extended for
It
a
has to be extended,
substantial time.
otherwise it
Miller,
cannot
the
be
matter
done.
be fixed, Miller, post vacation.
7 and 8. No other option but to extend it till after the vacations.
Yes, after the vacation. Kindly
Please
fix
come.
the date.
And Lordship, one thing in item number 6, we don't know whether that hotel or that unit is a part of the association or not. We don't know that because that has been because in item number 7 that has been filed by Mondaramani Hoteliers Association. So whether in 6 the petitioner is a part of the association or not, we don't know that.
So take it that it is independent and it is filing a
Lordship.
Affidavit
Lordship.
record in item number 6.
It can be used in 7 and 8 also because factually possibly it will be the same thing.
Since the highest law officer of the union is here,
Yes,
Miller,
yes.
let it be indicated in item number 8, no affidavit has been used by any of the union respondents.
They will use it. The central, this zone.
He is not appearing in item number 8, he's 7. He says.
No, 7, 8, both. It will come.
Very.
The coastal regulatory.
যখন অশোক চক্রবর্তী appear করছে, আপনার চিন্তা হচ্ছে?
All the parties have entered appearance in the matter. Stop. It appears that the matter is required to be heard. Stop. Some of the respondents seek time to file affidavit. Stop. The matter is fixed for consideration on 13th June, first Friday at first Friday after the court reopens after vacation for hearing. Stop. Pleadings shall be completed positively by 23rd of May. The interim order that is subsisting is extended till 30th of June 2025 or until further order, whichever is earlier.
My lord, only one thing, my
The
lord.
exception filed in item number 8 be kept with the record. I've given.
Please give.
My lord, as far as item number 7 is concerned, my lord, I am filing the supplementary affidavit on behalf
What are you annexing in the supplementary?
My lord, the list of hotels which
Yes.
were existence prior to the notification.
All right.
And my lord, reply to the exception, two exceptions and one affidavit in reply.
Circulate copies, please.
Yeah, copy served.
No, we did not receive any copy.
Union of India Central Pollution Board has received it.
Central Pollution
is not Union of
is different. It
Central,
is different.
I said Central.
So now, since somebody has appeared, please serve. Please serve copies upon all the parties.
They have
Right?
not used any affidavit, my lord. It is an affidavit in reply.
You are using the exception. Very well. Whatever is there, please circulate.
13th
My lord, let it be on record.
13th,
My lord,
13th June and 30th of
my
June.
lord, let it be on record.
It is certainly file it. It will be on record.
My lord, in item 7, my lord, affidavit in opposition to the
You file it. One thing, please annex the map where the wetlands or where the coastal zone has been demarcated. Without that, it will be very difficult to proceed. The state authorities are supporting them. So in case you have to come up with anything else, you have to place all those documents on record. Followed? Yes.
So, my lord,
Please file it.
Lordship has passed a common order in all the matters.
All matters.
Grateful, Lordship.
আমাকে দিতে হচ্ছে কেন?
Lord, the kindly recorded, my lord, on behalf of respondent petitioner in item number 7, my lord, we have filed it.
সুব্রত বাবু,
Otherwise, my lord,
সুব্রত বাবু, একটু দেখে নেবেন কে কোন মামলাতে কি দিচ্ছে, সেটা দেখে দেখে বসাবেন। আমার পক্ষে দেখা কিন্তু সম্ভব হবে না, আপনি একটু দেখে দেখে বসিয়ে দেবেন।
Only one thing, my lord, on behalf of the petitioner, in item number 7, my lord, one supplementary affidavit kindly leave be granted so that we can serve it, my lord.
Supplementary item number 7. Supplementary affidavit filed in court is taken on record. Let copy of the same be circulated.
And the exceptions to two reports and reply.
Yes, call the next matter.
My lord, I am appearing for the petitioner.
Yes.
My lord, it is a case, my lord, where, my lord, a complaint was lodged, my lord, in September 2022. Thereafter, no FIR was.
Before whom was the complaint raised?
For the officer in charge, Bobaja Police Station.
Right.
Thereafter, we took out an application under section 156(3) CRPC. Then an FIR was recorded, my lord. On 2 occasions, my lord, section 91 notice was given to the petitioner. We forwarded all the relevant documents, my lord. But as yet, my lord, no investigation has taken place in the matter, my lord. My documents have been manufactured, my lord. They are taking the plea that this is a case relating to the information technology, my lord. Cyber department would be the proper department. For this reason, they are not proceeding with the matter, my lord. Either, my lord, the case be transferred to the cyber cell, my lord, so that the proper investigation can be made, or let them
Let me
submit a
see
report.
your report, please.
This is a case where the petitioner entered an agreement for sale purchase of electronic items with the accused person. And the petitioner handed over a security check to the accused person. Now, the petitioner has come up with a plea that certain signatures of the petitioners
What
were
are
false.
changes have you called?
My lord, after the FIR, my lord, we are investigating the matter, my lord. Section 91 notice has been served upon the petitioner. Statements under the section 161 has been recorded, and we are further we are investigating the matter. We have called upon the license
Hand
officer.
over copy to me
My
and
lord.
to the learned friend.
My lord.
Let me see what is there. (2022) case registered.
Yes, my lord.
And still now nothing has happened.
Yes, my lord.
It was indexed based on a court cognizable complaint. For the Why don't you approach the court where you filed the 156 clause 3?
My lord, it is a high time, my lord. 2 years, my lord. We have twice they've given section 91 notice.
Right.
Now,
so you
whenever
should
we are
approach-
going and meeting the investigating officer, they say that the matter relates to the cyber crime because my email, my purchase orders were changed, my lord, on email. I have given a list of the purchase. It is not a case where security check on my business relationship. The sum of my purchase orders were manufactured.
See, the inspector in charge, you have a copy of the report.
My lord.
See, page number 2. The penultimate line is investigation into the case is in full swing. It was registered in 22, 3 years continuing, and the case, the investigation is in full swing. What? How long will the investigation continue here?
My lord, there are certain documents which
Never ending investigations. Where is the, what are the efforts that the police is taking to collect those documents?
My lord,
Please come. The petitioner is aggrieved by the inaction on the part of the officer in charge, Bobajar Police Station, in not properly proceeding with the Bobajar PS case number 260 dated 15th October 2022 under sections paragraph. The instruction forwarded by the OC signed on 21st March 2025 mentions that the investigation into the case is in full swing. Stop. The court fails to understand as to when the investigation will conclude. Stop. The case was registered in October 2022 and in March 2025 it is reported that the investigation is still in full swing. Stop. The officer in charge, Bobajar Police Station, is directed to take immediate steps for conclusion of the investigation. Stop. The Status of the investigation shall all along be communicated to the petitioner. Stop. Endeavor shall be taken to conclude the investigation at the earliest, but positively by 31st of July 2025. Writ petition stands disposed of.
Good.
Achha, instruction forwarded by the police be taken on record and handed over to the learned advocate for the petitioner. Yes.
Item number 10.
You are there for PNB. Last occasion, nobody was there. Yes.
For the petitioner.
Madam, to recall that there is a foreign LC remains.
Yes.
Now, from the day one, my lord is of the view that let us not go into the disputed question of fact. Without going to that, they say that they do not want money from the foreign country. Say consider to that. Now they say they will write a letter to the bank. Can you see the order dated 7th March? So they did not responded yet.
Not responded?
Not yet. I have an instruction also, my lord.
Yes, you have handed over 5th of March. 5th March. What is the date?
They have said I have already submitted the letter, my lord.
You have?
I have submitted the letter which what they wrote.
The earlier letter.
Yes, 5th of March.
Yes. Thereafter, this order was passed.
With reference to trail mail. No communication. Why don't you advise what is to be done? Maybe they do not know it.
Can you see the order is very clear?
Kindly, we know it. Now we understand what they're saying.
You've understood. All right. Now say, what is it?
The case is, first of all, my lord will take the case. Now they're trying to arm twist me so that the LC will claim withdraw from them, they will file the satisfy the charge, which I paid way back in 2021. Entire money. Civil, my name is recorded there. I am not getting loan from anywhere. My charges are not there satisfied. There is no connection with the LC. Now they are saying, unless you claim under the LC withdraw, then we are not going to file the charge. I am coming to that. My lord, we may take the first case. There is no one. There is 17864. 17864.
The next one.
Thereafter, later.
For file kadegi 11. Yes.
The company, this is small company, my lord.
Not this. Yes.
This is a company, my lord. They are manufacturing machines. The machines used for preparing cardboards, boxes, etc. Now they were enjoying 20% from the Hostile Bank, Oriental Bank of Commerce, now since March to Punjab National Bank. They have a cascaded limit in 2015. Thereafter, it was enhanced in 2016. In 21, we have closed the account. Closed them, paid entire amount. They cannot say any amount is due. I have the copy, that no dues, I have the copy, there's zero balance, 22. Then, my lord, we wanted that since we are enjoying cascade limit, we are not enjoying letter of credit limit. Letter of credit is separate thing. Is a solitary one-time transactions, a letter of credit opened by us. That has nothing to connection with them. Only thing is that amount to be credited in this account. We said letter of credit, whatever amount comes from foreign, that will be credited in this account. That is only relations. But charge.
The foreign country is not.
Is not a party.
No, it's not a party, but then it's not giving this fund to you.
Fund will be given by them. That will come. That is the next case, my lord. As by credit limit with the working capital limit with the bank on that in that I am issuing. I am enjoying working capital limit. I created charge on the stock, store, raw materials, finished goods. The charge was filed with the ROC. By filing the necessary form, then it was modified, increased limit. Then we want satisfaction of charge because I have paid internal. I am not enjoying any credit facilities. When I ask them that you file a no due certificate, they can't say any amount is due to them. They did not pay. Then I filed a writ petition before the Honorable Court, that's Honorable Justice Pandakasuri, that they did not, you are not present. So Honorable Court said you may submit a representation, they will dispose of it in time. They did not reply to that. Thereafter, I filed a contempt. In the contempt, when I filed a contempt, they replied. That is the cause of actions of filing this case. Now, my lord, Firstly, my lord, look into that. Let me come. Page petition, my lord, page 3, paragraph 2 of the writ petition.
In the writ petition, page 3, paragraph 2. Yes.
Originally, the petitioner opened a cascade account on 2nd December 2014. The Austral Oriental Bank of Commerce, Kakurgachi branch. Be it mentioned here, subsequently, Oriental Bank of Commerce was merged with the Punjab National Bank. Then, paragraph 4. That the process of closing in the month, this paragraph 3, that sometimes in the month of November 2021, the petitioner decided to close the cascade account. The same decision was taken by the petitioner due to some development in the company. 4. That in the process of closing the cascade account, the petitioner paid back the respondent bank a sum of rupees 45,60,000. Subsequent that the petitioner again paid rupees 2,892 600. And the payment was made on 15th of November 2021. It is further stated in this condition the said amount was duly acknowledged by the. So therefore, entire amount was paid by on that day. Then my lord, they did not. Thereafter, a lot of letters are there to no due survey. Then, my lord, let me go to the annexures. Annexure, my lord. P1, amounts are paid. Then, my lord, I asked for the closure of the cascade account. So, because you are therefore required to satisfy the charge ROC. If the charge in the ROC effect is that I will not be, my name will be reported in the civil, I will not get any loan from anywhere. ROC charge is there on my assets, no bank will grant me loan. But if the no dues is there, no dues in the cascade account is there, because charge in the cascade account, not LC, nothing. I have not taken packing credit, I have taken cascade only. So there no charge was there. So therefore, I asked for ROC to file the charge. Then, my lord, again a wrote letter, Joral with Punjab National Bank. One after another went to writing letters. Thereafter, my lord, they came back. Then, my lord, by page number 29. Page number 29, my lord. These letters capture everything. Second paragraph. We have now noted the contents of the email where we have intended to know always to close the cascade account, but you were unable to do so because LC pending closure is due relations. Due relations, certain charges of certain charges of your overseas Kolkata bank. You have further inquired. For the past, you have claimed in your said email that you are already informed me about the pending charges. So some charges were due that they said for that reason we are not closing. Thereafter, my lord, I went to the court. Then they came with this letter. I went to the court order. I wrote to the ROC also to satisfy the charges. Page 45, my lord. No dues are there, so satisfy the charges. Page 45.
Now tell me what is to be done.
No, but they will file they will give the no dues certificate. If they say some dues are there, we'll pay. No dues are there for 21.
Now that they admit that they do not have any dues.
No dues, and then ROC charge is to be filed. That to sign the ROC charge because companies are required the satisfaction of charge form to be signed by both the parties, charge holder and who created the charge. They must not have an objection.
Do you still intend to recover the money from the foreign country?
Yes. For that is the other case. That has no connection with this. I have not.
No, the previous submission was that you forego the whatever due is. That was the previous submission.
Advocate changes the stand also.
Yes, with a change of advocate, there is a change of stand. Yes, yes, that was the stand.
That is why it's an order, 7th March order. So we can clearly submit that.
No.
Order
anyway, my lord, from the records which are understood, my lord, that is different.
That was the submission. That the petitioner forgoes.
LC mechanism, possibly they have understood it. They thought that the Punjab National Bank has no life. Now, my lord, foreign bills is separate entity. Once upon a time in 2015, 16, they advised the Punjab National Bank advised me that I am opening the LC in your favor. In terms of the LC,
If you send the goods to Bangladesh, then we'll pay the money. They will get the money from the foreign bank. For a foreign party advised the LC to the Oriental Bank of Commerce. Oriental Bank of Commerce advised us. Accordingly, we prepared the machineries, and we have exported the machineries. We have not taken any packing credit means in the banking parlance. For the purpose of concluding export contract, if I take a loan from the bank, I create charge the receiver. But I have not taken loan for that. I have not taken packing credit for completing my LC obligations. So I prepared everything, transmitted transport documents. That is the second case, my lord. I will come to that. That all the documents are prepared. It was submitted to them. Thereafter, they say the one packing credit list, there is no signature. But they did not tell me within 5 days because we have to go to the UCP 600. Because on entire trade is the lifeblood of international bank and commerce, international banking and commerce. So you would depend on the rate of credit only. Because importer, exporter, they don't know anybody. They have an underlying contract. There is 3 legs matter. I will come to that. 3 legs. One is importer, exporter, interest to contract. Then exporter, interest to contract.
Now tell me what is to be done. The
First of
bank
all, they have
has
to file
disclosed its stand.
They have to no due certificate.
For the purpose of issuing the no due certificate, some undertaking or something has to be given from you, if you can recollect correctly. What is to be given by
7th
them?
March order, kindly see, my lord.
7th of March.
7th March order.
There is an RBI circular.
Yes, yes.
RBI circular. Let him show the RBI circular. It is necessary to close the LC unless the LC is closed.
No. No, you have to approach the Reserve Bank of India
That is their saying.
to write off. RBI circular says. 1st July 2011. Where is the RBI circular?
Let them show the RBI circular that closed the cascade account and to reserve account. LC
For writing of the dues.
No, writing of dues, the LC under LC. LC is not the charge. There is no connection
All
with
the
charge.
dues are required to be mentioned in the letter to be addressed. The petition is required to take action in terms of the RBI master circular
LC charge
mentioned here in above. Did you hand over a copy of the RBI circular?
Along with the email also.
Did you? Do you have a copy? You must be having a copy.
No, that is not the circular. Circular, I have a copy with that, but I have sent them in the email also. I have a separate copy.
RBI circular nowhere states about the closure of my cascade, my whatever account, studies account. That is into LC. I am not concerned with the LC. In the sort of satisfaction of the charge. On 21, my company completely ruined by that. Civil is not giving.
Did you go through the orders passed by the court?
Some orders have gone.
The last order.
Asked us, they had to go there. We have went there. We have given the letter, copy letter is to us. Thereafter, they answered that letter I have given to us. On the last August, I gave the letter.
Because all along the submission was something different. Today, a different submission is coming in.
What is the submission?
Yes, submission is recorded in the order. Please see the last 7th March 2025 order.
Before that also.
Before that also. All orders are there in the server.
Orders are there,
7th March is there, 25th.
Order is there, my lord. 7 March. All orders are. Nowhere it was directly the
circular. Where is the circular? Did I keep it in the other file?
The circular which we mentioned on 5th March order. I mean letter.
Yes.
We order 21st.
Did you hand it over to the
Yes.
court? When in that case, it must be here.
Have extra copy also.
No, I'll not keep extra copies. I'll go on multiplying copies in that case, and everything will get lost.
Then my order is me, my lord. In this particular case. Transaction machine. No. 7 March order.
You have already filed an affidavit. Is it annexed?
Yeah, annexed.
Please tell me the page.
7 March order is minimal.
No. This circular which we annex with our affidavit, that is on some different context. Then when they changed their stand, when they said that they do not want money from the foreign country. So this is candidly submitted by me. It is following from my lord only. They let them write off the account. They do not want money from the foreign country. For that, there is circular, which we send them in the email also, and copy I have with me, and they have served them also. So we have to abide by that.
Do you have a copy of the circular which is recorded in the order of 7th of March 2025, paragraph number 2, 1st July 2011 circular?
Enclose some surplus matter with their affidavit.
Yes, that is separate.
If this is circular not there, let them furnish a circular. I will go through it. But
Please.
I'm 100% sure, my lord, that circular deals with LC.
I do not know because the submission was of writing of the
Yes, correct. Yes,
amount which is recorded in the order. Please come.
Now this order was never challenged by anywhere. So they have to abide by that.
Which order?
The 7th March order.
What is that 7th March order? In communication dated 5th March by the authority signatory Punjab National Bank, what the petition has been brought to record. The said communication mentions that as per the RBI circular, dated now, this petitioner may approach the
please come.
My lord, there is no direction upon me.
See, there is a direction upon you, paragraph number 2, last line. The petitioner is required to take action.
In the terms of RBI master circular mentioned therein. That circular has nothing to do with cascade matter.
Now, this is a submission which has to be gone into and see what to be done. The heard submission made on behalf of both the parties. Stop. Affidavits are over. Let the matter be fixed for hearing. In the monthly list of June. Give a circular. Yes, yes.
Last time also.
But then it must be there in your file. If last time he has given, he says.
What is circular only annexed to the affidavit?
That is separate. Something separate is something separate. Monthly list of June, there might be some other advocate. Still, nothing is there. But may I request only one thing, madam? May I request only one thing?
Yes.
Since this FEMA and all are involved, RBI is the necessary party here, according to me. The LC is involved. The foreign money is involved.
Yes.
Let them add party to the RBI. Let the RBI respond to this. Why this LC is there pending?
Well, the cascade account and LC completely different. They try to mix up with that. Let it be hard, my lord. That necessary, my lord may direct me. I can bring the RBI. If they are unnecessarily not going to satisfy, because I have a claim. Reason is that, my lord, I have a claim against them. I'm maintaining that claim. That's why they are arm twisting me. I will not give a satisfaction unless we withdraw it.
I do not know.